Friends, welcome to the 80th session of Legal Empowerment Through Interaction lecture series. It has been a wonderful journey, and now that we have reached 80, though we may be old in the number of 80, but we are all energetic in the sense like we are ready to take up on any topic that is put to us. But today we have got a wonderful topic regarding which or in the subsequent lectures that is to come in the days to come, decoupling free speech from the yoke of criminal defamation restraints. It is as if one view that is possible is absolute freedom, but it can also be depicted as power corrupts, absolute power corrupts absolutely. Let us see. Today, whatever platform that has been, whatever premise that has been, that will be created today, will be left to the deliberation for the coming week, and we would like to have food for thought. And to initiate these deliberations and to introduce the topic, we have a wonderful speaker, a wonderful faculty who had addressed us earlier also, and he was very familiar to us. It is Justice Jayasankaran Nambiar, and we are privileged with the presence of Justice Ramkumar sir, Justice Ramashan sir, and all of you wonderful persons, participants who have been part and parcel of this wonderful journey, which led us to this 80th session. It was rather impossible without these sort of interactions, deliberations, which kept us sane in this COVID times. Let us hope that whatever crisis that may come in future, let us keep the journey afloat. Over to you, Jayasankaran sir.
Good afternoon, everybody.
Good afternoon.
Whenever I get a phone call from Shyam, I always answer it with an apprehension, and it always sends a shiver down my spine, because it is invariably going to be followed by a request for something of this sort. During the lockdown period, I had attended a couple of webinars and I participated in them, but immediately after the court reopened after vacation and I was sitting through video conferencing, I had sworn that I would take a sabbatical. I would not come for webinars because it is too much of a drain on my time. But here you have it again. I received this call again yesterday, and he said that I must come and speak for 5 minutes. And this has forced me to now redefine what a webinar actually means. And Sujitha, this is for you also, because you just mentioned that it was your first time here. I've come to see webinars as a seminar that follows the entrapment of a speaker in a web of deceit spun by the organizer. I think that would neatly encapsulate what is going on in my mind tonight. Having said that, the topic that drew me into this web was a fascinating one, because it is decoupling of free speech from the yoke of criminal defamation restraints. It is fascinating because it is a topic that comes straight from constitutional law, and I'm not only an ardent admirer of our constitution, I'm also a passionate research student of the constitution. I like to see myself as one. So what is it that we're talking about? Let me just give you a brief description, because the views that I find, and I found to my horror, are most diametrically opposed to what the speaker is going to be speaking about today. I had this discussion with her yesterday, and she was very passionate about her point of view. I tend to be very not so passionate about my point of view, because I'm sitting in a position where I have to look at rival views. Freedom of speech and expression, as all of you know, under Article 19(1)(a) is one of the fundamental freedoms that has been assured to citizens of our country under the Constitution. Like all other rights guaranteed to our citizens, this too is not guaranteed to citizens in a pluralistic society. This also is not an absolute right. It is definitely hedged in by restrictions. The restrictions have to satisfy the test of being reasonable. And when it comes to this particular right, which is traceable to Article 19(1)(a), you have to satisfy the reasonable restrictions under 19(2). So let's see what 19(2) says. I have a copy of the Constitution with me here. I refer to it every time I have a doubt. 19(2) says that nothing in clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the subclause. The following words are important. In the interest of sovereignty and integrity of India. That's the first one. Second, the security of the state. Third, friendly relations with foreign states. Fourth, public order, decency or morality. And fourth, in relation to contempt of court, defamation or incitement to an offense. I want all of you to focus on the last one. In relation to contempt of court, defamation or incitement to an offense. Now you see, whenever you're talking about a reasonable restriction under 19(2) of the Constitution, you must realize that it is a reasonable restriction imposed or permitted to the exercise of a fundamental freedom under 19(1)(a). The justification for having reasonable restrictions is always overriding public interest. So they see that a fundamental right that is assured to a person or a citizen can be taken away if it is justified in overwhelming public interest. So you have the various heads of restrictions which can be there, which can be imposed, and they all satisfy, they're presumed to satisfy the test of overriding public interest. And it is in one of those restrictions that you find the restriction with relating to defamation, laws of defamation. It is important because you straight away find that any law that is there to prevent the to safeguard the reputation of a person or to prevent defamation is something that is enshrined in our Constitution as a reasonable restriction to a fundamental right. And it is there because there is an overriding public interest involved in protecting that right to reputation. Right. What happens to the right of reputation? The right to reputation now, as you all know, after Puttaswamy, is become an integral aspect of the fundamental right to privacy. And fundamental right to privacy is traceable to Article 21. What does this mean now? The right to reputation is now a fundamental right in itself, and it is traceable to Article 21. Now look at the situation where your fundamental freedom of speech and expression is now restricted to protect the fundamental right of a person to guard his reputation or to his reputation. We are not going back to the silos theory of Gopalan days. After R.C. Cooper, you all know that when it comes to a challenge or it comes to an argument regarding violation of fundamental rights, you look at the effects of either state action or any action on the fundamental rights of the person affected. If a particular action has the effect of violating a fundamental right of a person, either under Article 21 or under Article 19, you look at what that does to the person to determine whether there is an infringement of his right. You're no longer looking at compartmentalizing it into various heads like Article 19, 21, etc. In that scenario, assuming that there is a person who exercises his fundamental freedom of speech, and in that process, he violates or infringes the fundamental right to privacy of another person. And in this particular case, the reputation of another person. Something that one person says affects the reputation of another. If you look at it in the context of conflict of fundamental rights today, the law in our country today says that when there is a conflict of two rights, a fundamental right of one person vis-a-vis the fundamental right of another person, you would have to reconcile these two by giving or upholding the fundamental right that advances greater public good. You had this in a case, the recent pronouncement of the Supreme Court was in a case that involved the agitations in Jantar Mantar, for example. There were rival fundamental rights in play. The freedom of speech and expression to all those gathered in Jantar Mantar for the agitation, and they were claiming their right to free speech under Article 19(1)(a). It was pitted against the fundamental right of the residents in the locality who claimed that they have a right under 21 to live a life free from any disturbance, peaceful environment. When it came to a question of reconciling both these, the Supreme Court found that the right of a resident to peaceful residence and a right to a peaceful environment was the one that advanced greater public interest. And therefore, the fundamental right of freedom for speech and expression should give way to the larger right which advances public interest. So when you apply the same test here, we would have to see whether it is the fundamental freedom of speech and expression or the fundamental right to privacy or to protect one's reputation that should be given a greater place. And that is where the mention of defamation under Article 19.2 becomes important, because 19.2 is recognized exceptions which are there in furtherance of public interest. And therefore, you have the right to reputation or preserve one's reputation put on the same platform as other interests which are in public interest, like sovereignty, integrity of India, security of state, friendly relations, etc. And you can impose reasonable restrictions on your fundamental freedom of speech and expression. So if that is in public interest, then surely it is the freedom of it is the right of a person to his reputation, to safeguard his reputation, that must be termed as a superior right, and free speech must therefore give way to the larger one in public interest. So my take on this would be, in the face of the developing law and in the light of the constitutional principles that we have evolved, you cannot really have a decoupling of the free speech from the yoke of criminal defamation, because criminal defamation is there to protect the reputation, and that reputation is the larger right that has to be advanced. Right. I think I've done enough damage as far as putting pressure on the speaker is concerned. I would, as I said earlier,
add something to that, in the sense like, yes, if you had had half an hour or 1 hour of interaction yesterday, we did have 2 hours. She wanted anonymity, which I said is impossible. So that's added pressure. Over to you, Sujitha.
Right. Thank you very much, actually, for that really interesting introduction, because now I think I have the motivation to fight back. Before I start, please take it from a researcher that we are pretty critical of judgments, and it's got nothing to do with the person writing the judgment. So I am going to be pretty much criticizing the way the judgments have been written, and I hope to try and bring you over to my side with respect to this balancing between these two articles. I think there is, however, a small point I wanted to make, which is that perhaps you may have misunderstood when I wrote about the silos. I wasn't actually saying that we need to go back to the period of the silos. That was not what I was mentioning. What I was mentioning was that the way it has been currently dealt with in Subramanian Swamy case is as though we are back in the age of silos. That's what I was mentioning, and I'm against it, actually. So before I start, in order to give some sort of like a pattern, a logical flow to the presentation, I think what I will do is walk the audience through how I started or arrived at this point. The reason why I'm doing it in this particular flow is not necessarily because it is, it's of any specific importance as to how I reached this point, but simply for lack of logical structure in my thinking currently, because it's all quite floating and fragmented at the minute, and I just need to give it some structure, and therefore I'm just using the structure. It's pretty arbitrary, but that's the way it is. So my introduction to Indian constitutional judgments is actually quite recent. The first case that I read in utter detail was the Kaushal versus Nas case, which was so poorly written. The judicial reasoning, even though the idea of judicial deference was pretty good, the reasoning was done in such a poor way that I simply had to write to say this is not a case of judicial deference, but this is rather a case of judicial abdication. They've not really done the job of a judge, and the process of the judicial decision making has been completely withered away in this particular case. So I wrote an article on that, and of course that got me interested in the related cases around it. Was reading through Navtej and so on and so forth, when there was this a little outbreak of cases where the Supreme Court started using the concept of constitutional morality. That was pretty intriguing, because the judgments seem to be going all over the place. The definition that was being given to constitutional morality was so fluid. At some point, the judges were saying that this referred to the form of the Constitution. At other points, the judges were saying that it referred to the substance of the Constitution. You could pretty much use constitutional morality in whatever form and way that you need in order to arrive at judgments. Now, I do admire that they use the concept in order to come up with some progressive judgments and some apparently progressive judgments. But the fact that they were using constitutional morality in such a fluid way was quite interesting from the perspective of a non-legal practitioner. And the reason being that practically every single judgment that did refer to constitutional morality in any depth always sourced the issue to Ambedkar's speech in the Constituent Assembly. And Ambedkar, of course, the definition that he had given was more or less to do with it was a cut and paste of the definition that was written by George Grote. There are some judges who have mentioned George Grote, but not really gone into any discussion about George Grote at all. So for instance, I mean, for the students who may be listening, George Grote is a philosophical radical who wrote or created this revisionist narrative about democracy at a time when democracy had been pretty much bashed up by Plato, Aristotle, anyone who followed the Thucydides version of the Peloponnesian War, where democracy was seen as a form of demagogue, popular rhetoric, and so on and so forth. And what George Grote was doing was effectively trying to showcase the good side of Athenian democracy. But in order to do that, he had to justify, or he had to whitewash some of the most shameful episodes of Athenian democracy, and also some of the most controversial features of Cleistinian constitution. So, for instance, when he talks about constitutional morality, he uses it in order to justify ostracism in the Cleistinian constitution. And similarly, when he talks about the execution of the generals without any form of natural justice, without any application of legal principles as we see today, he uses or justifies it using constitutional morality. So actually, when constitutional morality has been used in order to justify some of the most shameful episodes of democracy as such, and also the shameful features of the Cleistinian constitution, I found it pretty surprising that it was being used in ways that was completely unanticipated in the judicial decisions in the Supreme Court. So, of course, why and what makes us go in this direction, why the sudden outbreak of this concept, that was pretty interesting. And I was writing my paper on it, and I'm not finished, I'm midway through it because I was trying to read through the constitutional making process of the Indian Constitution, read in alignment with the nation making process as such. So it was at this point that I was more or less contracted to provide consultation support for a free speech case in Singapore. And that's how I got into the discussion on free speech issues, because that was completely new for me. And just to bring the comparative perspective, the Singaporean constitution more or less takes after the mother constitution is Malaysia, of course, because Singapore was part of Malaysia. But the Malaysian constitution was written in a way which is very different from the way, for instance, Indian constitution, many other constitutions which were written when they came out from the colonial yoke. So for instance, instead of the Malayans writing the Malaysian constitution, it was a case of them asking for a consortium of different nations to sit together to write the Malaysian constitution. So you had, for instance, of course, the name that one can all anticipate, Ivor Jennings. Then the chair was Reed, so it was Reed Commission report. And we had a justice from India, Justice Malik, I think, yeah, from the Allahabad court. There was Justice Abdul Hamid from Pakistan. There was some McNell, I think, from Australia. There was also a seat for a Canadian a scholar or a jurist, but he was unable to join for ill health. And they made all their way to Rome to write this Malaysian constitution because they wanted to be writing it in a very independent fashion. So when they wrote the Malaysian constitution, the fundamental rights chapter was more or less lifted from the Indian constitution. Except at the time that it was submitted, the Reed Commission report was finalized and was going to be submitted, Justice Hamid comes up with a statement that he was not happy with parts of the constitution, part of the draft that was written, something which surprised the rest of the committee members because it was something that they said he had not mentioned at all as part of the conversation. And I have not had the chance yet to look through Ivor Jennings' original papers. The libraries are closed and so on, but I have looked through the secondary resources at the minute. And it seems what had happened was that Justice Hamid more or less advocates for the removal of the word reasonable from the restrictions, from the word restrictions in the Constitution. So for instance, it says, yes, you have the freedom of right to speech and expression. However, there will be restrictions which can be imposed on by the legislator for XYZ reasons, being, for instance, national security, there are two categories effectively, which was taken to the Singaporean constitution. The first category being national security, sedition, those kind of issues, which has a proviso of necessity and expediency connected to it for judicial scrutiny purposes. But the second proviso, which includes defamation, contempt of court, and so on, the second proviso doesn't have this second category doesn't have this proviso of necessary and expedient provision, which is quite interesting, actually, come to think of it, because one would think that if judicial scrutiny is necessary, it should be necessary for things such as either for both the categories, or you could say that the idea that the courts will have judicial scrutiny for legislatures which tries to prevent issues in relation to national security, but will not have judicial scrutiny in relation to issues such as defamation was pretty much out of character. I think that's something which the Singaporean Constitution will change in the future in relation to that. But the more interesting point for me was the question about, or the lack of the word reasonable in the provision. And what I would have argued is effectively that the word reasonable should be read into the Constitution, considering the fact that the Malaysian Constitution, despite the fact that it doesn't have the word reasonable, also the judgments in Malaysia have started reading the word explicitly, have started reading the word reasonable as part of these restrictions. And another aspect of it, of course, was the issue of proportionality. Proportionality is something which is not adopted by the Singaporean constitution. And the reason why they didn't do it is pretty strange as well, because they say that proportionality is not a part of common law, and according to the judgments, it is something that has been artificially injected into the English law because of the fact that the UK is part of the European Union, and therefore, considering the fact that it is not part of common law, it need not necessarily be read into the Singaporean constitution. So, of course, that is also something that needs to be changed, because proportionality, doctrine of proportionality has become more or less a universal principle now. Yes, it comes from the it has German origins in administrative law. It's now been read into constitutional law. And of course, it's now being pushed quite seriously ahead by the Canadian jurisprudence, by the Israeli jurisprudence, by the South African jurisprudence, and so on. So it has become more or less pretty universal, and the way India reads it is pretty slightly interesting, because, for instance, the recent Indian judgments do refer to the 4 test, as we see in the European jurisprudence, but some of the judgments actually refer or state that proportionality is something that we always had, which was actually done in a way differently than the 4 steps, and that kind of causes a bit of confusion, because do you use the 4 steps or do you use the one that was used previously? But never mind, it is still, it is pretty much clear that we do use the doctrine of proportionality, so there is no, there's no debate as such in relation to that. So in any case, so the issues that I was trying to raise was the question of reading in of the reasonableness, the doctrine of proportionality, and of course, presumption of constitutionality. It is one of the pre-constitutional laws. The provisions for criminal defamation come from colonial from the colonial period. And this is something which, for instance, India, from the judgment that I have read, so for instance, I have not managed to read one of the most recent judgments, Mahesh Murthy versus Pooja Chauhan. I think it came out last week, and I have unfortunately not managed to read that because the reading of the other judgments have pretty much taken all of the time. I mean, Indian judgments are so long. It takes time to you know, to absorb it, not just read it, and so yes, it's a slow process, and unfortunately I don't know what Mahesh Murthy says in relation to presumption of constitutionality issues, but in general, one of the main judgments in relation to criminal defamation in the Supreme Court is the Subramanian Swamy case, and in that case, they don't really discuss presumption of constitutionality. I also have not managed to find, I searched the court website quite a lot. Maybe I'm doing something wrong. I have not managed to find a particular judgment which I'm looking for. This is the case of Pillai, Priya Pillai. And I think this was a case which was filed against her by SR. And this was, a question was posed whether corporations can file a complaint against an individual for defamation. And more or less what the court was saying was, yes, of course, a corporation can file a case against individuals. And of course, corporations tend to use it in order to prevent any sort of a discussion in relation to environmental harm that they are causing, and so on and so forth. So it's not just a question of 2 individuals fighting each other, which is how Puttaswamy had mentioned or referred to Subramanian Swamy, because when Puttaswamy referred to it, it said, well, Subramanian Swamy had looked at the judgment of Subramanian Swamy had looked at this particular issue of these 2 individuals, one fighting against the other, and then of course tried to place Article 19 against Article 21. Now, so yes, I'm now digressing. The point I was making was that what I understand from the Priya Pillai case is that also in that particular judgment, the judge simply had referred to judicial deference and more or less stated that that's what is there written in the statute book. Yes, corporations can file these cases, but they did not look into the question of presumption of constitutionality of pre-constitutional laws. And why is it necessary to look at presumption of constitutionality of pre-constitutional, this particular pre-constitutional law? I mean, we have successfully dealt with it, for instance, in relation to 377, to try and we have mentioned about it in various other, and have a whole list of cases where we have actually dealt with or talked about the issue about colonial legislation and trying to determine whether it still represents the will of the people, considering that it's a pre-constitutional legislation. Now, I do want to have sort of a brief, go through a brief historical narrative about criminal libel, because I think that will set the scene for me when I am arguing the point that this is not a case of Article 19 being set against Article 21. In order to do that, I think it's necessary for me to go through the historical narrative just briefly. So the crime of libel is a common law misdemeanor. And of course, when we're talking about the crime of libel, we're talking about offenses in relation to seditious libel, blasphemous libel, obscene libel, defamatory libel, and so on. My focus is only at the minute on defamatory libel, even though I do think that the other types, such as, for instance, public order issues that we are covering and so on and so forth, can also pretty much be abolished, or at the very least be read down as narrowly as possible. But that's not, I don't even want to go there. I want to focus on defamatory libel. So the earliest form of libel that we know in English law is the offense which is of criminal nature, known as the scandalum magnatum. Now, this was an offense which was created in 1275, and the wordings that what it actually states in this particular statute is, and I'm quoting, "None be so hardy to cite or publish any false news or tales whereby discord or occasion of discord or slander may grow between the king and his people, or the great men of the realm, and he that doth so shall be taken and kept in prison until he had brought him into court, which was the first author of the tale." So the mischief that the statute was seeking to prevent, obviously, was causing a loss of faith in the government or the monarch. And so quite clearly, one of the earliest forms of libel was seditious libel. It does refer to slander, but it refers to slander in relation to the great men of the realm. So the great men of the realm, who is being slandered, and we don't quite know a definition in relation to that, what actually we are talking about. We will come to it in the subsequent judgments and so on. This is what is a mischief that the criminal libel was trying to prevent. So you have the criminal defamation, where someone can actually go to prison, but the purpose of that was for seditious libel, and this was punished, of course, by imprisonment. And all the other, people who were victim of defamation, they were obliged to go to the ecclesiastical courts. Because under medieval law, there was no remedy as such, which was offered in relation to the other forms of defamations by other people. So, but things started changing or developing a little bit when the printing press came about, because of course with the invention of the printing press, you have the possibility of being able to print loads of material which can easily be distributed among people, and that can cause perhaps a rebellion against the church or against the state and so on and so forth. So obviously the state and the church, which at that time was pretty much in close coordination one to the other, were quite keen to prevent any sort of such rebellion taking place. It was quite necessary for them to then come up with some sort of legislations stating that anything that is being printed effectively must be licensed. So you have pretty much a way in which you're trying to monitor and suppress what is being printed by anyone, by people who have the printing press. So it was during this period, 1488, I think it was the Star Chamber that was set up, and the job of the Star Chamber was to monitor, suppress the criticism to state and church, and this was something that was closely concerned with the issue of seditious or blasphemous libel. But the Star Chamber also wished to suppress something else, and this is really interesting. They wanted to suppress duels which were taking place. So this was pretty fashionable at that point in time. The nobles, aristocrats, their honor is, if it is insulted by the other person, by another noble, for instance, would say, let us have a duel. We will duel it out. Duel by dawn, I don't know, by pistol or by sword or whatever it is. But they will duel it out in order to fight for their reputation and fight for their honor, to vindicate themselves. And this was something that was actually supported by the Star Chamber. So here you're talking about libels, which affects the integrity of the private individual. But the nature and task of the Star Chamber and the Common Law Court were therefore altogether different. So while the Star Chamber is trying to discourage matters which threaten state security, matters which affect the breach of peace through criminal defamation, the Common Law courts were more concerned with the rectification of damage which is done to the reputation of an individual. So here you're talking about civil damages, where you're talking about the when we're talking about the rectification principle. So you have, for instance, the tort and the crime of libel, and this is where it reached an intersection point. The intersection point being the case of defamatory libel. So it comes because of the way the Star Chambers were dealing with it, and because of the way the Common Law courts were dealing with it. And so effectively at that point in time, of course, we didn't have this this kind of a clear division of seditious libel, blasphemous libel, and so on. The way they divided was pretty simple. It was like political libel and personal libel. So the rules in the Star Chamber, it kind of, as we can see, developed differently from those in the Common Law courts. And it was sufficient if, according to the Star Chamber, if the libel was published only to the victims. So for instance, now when we look at our legislation, we talk about that it affects, what's the word, a third, lowers the morale in the estimation of others. That's explanation 4 of section 499. So no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the morale. So here we're talking, when we're talking about libel, now criminal defamation, now we're talking about it from the perspective of how it is dealt with in others' estimation. Just like in the Lord Atkins principle, right-thinking members of society, what would they think of you if your reputation is being affected? So, so effectively, what is your position in society? That is what is taken into account. Meanwhile, if you look back at the Star Chambers principles, what they were, the way they were applying it, they were applying it for seditious libel to ensure security of the state, peace, maintenance of peace, and so on and so forth. And the way they applied it was that you didn't really need to show it was a third party was aware of it. The libel was sufficient if it was published only to the victim and no one else. So it's just between two people. And why? Because of course they wanted to support the idea of this duel taking place, and they did not want the dueling aspect to actually create issues of security as well, because they don't want two sets of people, two aristocrats, for instance, fighting one another, which can cause not only a problem between these two as persons, as individuals, but potentially the repercussions of two people dueling can, in effect, affect the king. If, for instance, these two families maybe, for instance, start hating each other and so on and so forth, and this can potentially create a bigger problem as such. So if, in effect, what I'm trying to say is that the way that the criminal defamation developed in the Star. So that was one aspect. Another aspect that we see, the way that the Star Chambers dealt with criminal libel, was that the rule of the truth was not a defense. So if you, just because you tell the truth, it doesn't actually give you a defense. In fact, it was the opposite. It was a contrary principle that was expressed. There was a very well-known phrase which said, the greater the truth, the greater the libel. So telling the truth is what can actually cause the libel rather than the other way around. In fact, there was a very sexist example that was being given at that point in time, is that a woman, as a woman said, she would never grieve to have been told of her red nose if she had not one indeed. So, of course, the issue was that, the true libel was therefore greater. It's a bigger problem because of its greater potential to provoke a breach of peace. So, more or less, what this does is it reinforces the obvious fact that the developing criminal offense of libel had nothing to do with reputation and much more to do with the issue of maintenance of the public peace. So the Court of Star Chamber was, of course, abolished 1641, if I'm correct. And after the restoration, it's the criminal jurisdiction in relation to libel was then inherited by the King's Court of the King's Bench. Now, the result was, of course, that the pre-existing civil law of defamation and the inherited criminal jurisdiction in relation to libel was now being administered by the same court. And of course, this can result in two sets of rules interacting one with the other and the resultant consequences in relation to this interaction. Now, the criminal aspect of defamation was obviously largely influenced by the Star Chamber rules, and the civil aspect was therefore influenced by the common law rules. And the interaction of the two sets marked not only by the retention of a separate crime and a separate tort, but also by the growth of distinction between libel and slander. Now, the rule that truth was not a defense to criminal prosecution, that persisted for quite a while. It persists until, almost 200 years it persisted after the Star Chamber Court was abolished. I think it was in 1843 or 44 that the Lord Campbell's Act came about, wherein they said that truth can potentially be treated as an offense, but truth can only be treated as an offense in addition if you show that there was a public interest as well. So it's not just truth, but there must be a public interest in addition to the truth. So you don't just tell the truth, but it has to be for some public good. That is something that we also see in our defamation law. So for instance, our defamation law, the defense that is given in a defamation law is that yes, truth could be a defense, but truth only when it also is in combination with public good becomes a defense. That is something that we still carry over in our legislation. Now, so effectively what we're seeing is that we see the absorption of the the crime of libel from the Star Chamber to the common law courts, and some of the effects of the interaction of the civil and criminal rules. And it's around this point also that obscene libel comes into picture, but I want to touch upon it now because it's not really part of what I'm talking about. But at one point, criminal prosecution did become popular for a short period, actually. And the reason why criminal prosecution became popular for that short period was because the defamatory attacks at that time by the press was pretty scurrilous in nature. And the aristocracy, well, they were always the victims of these defamatory attacks. They didn't really need the money, so that's why they weren't going to the civil courts. And also, the civil courts did not have, could not order injunction, whilst the criminal courts effectively could make the libeler find securities for future good behavior. So obviously, it made sense for the person who has been libeled to try and look for protection through criminal prosecution as opposed to civil prosecution, simply because, of course, in terms of criminal prosecution, truth was not a defense as well. So obviously, it made sense to go to the criminal courts as opposed to going to the civil courts, the common law courts. Now, the press, of course, started protesting. There was a lot of lobbying going on as to why the changes should be made in relation to that. And eventually, the there was resulting legislations made, the Libel Act 1843, wherein effectively they stated that yes, you can actually take truth to be an offense, however, it's only for public good, which I already mentioned. Anyway, so what I'm trying to effectively show here is that we need to take into account the issue of the history of how it all came about. Now, of course, why do we have it in the form that we have it? The colonial legislation at the time that was written was clearly to try and prevent the establishment from being questioned. There was obviously very many ways in which they had tried to put this in place. So, for instance, if you look at the Criminal Procedure Code, Section 199 deals with the prosecution of defamation, and Section 199(2) is pretty interesting because Section 199(2) effectively states that notwithstanding anything contained in the code, when any offense falling is alleged to have been committed against a person who at the time of such commission is the President of India, the Vice President of India, the Governor of the state, the Administrator of the Union Territory, the Minister of the Union or the state or the Union Territory, or any other public servant employed in connection with the affairs of the Union or the state in respect of his conduct in the discharge of his public function, then a court of session may take cognizance of such offense without the case being committed to it upon a complaint in writing made by the public prosecutor. So effectively what has happened is that the criminal defamation was being used, and I have come across quite a few statements which have been made, but I do need to look up the National Crime Bureau statistics and details from there. But effectively what is being done is that, for instance, the Jayalalitha, the state of Tamil Nadu, for Jayalalitha, had instituted hundreds of cases against judges, against newspapers and against particular certain journalists, because you can effectively bring the might of the state against the journalist. So the politician themselves do not have to go and file the case. Literally, the state can file the case for them, and the might of the state, in terms of money, in terms of resources, in terms of the availability they have for expertise, in terms of judges and in terms of lawyers, all of this, the might of the state can effectively be used against an individual who writes something or the other, which the public authority might find to be defamatory. So, let me go to the provision itself, Section 499. What I'm going to do now is actually just mention a couple of the issues in relation to Section 499 before I come to my final point about Article 19 versus Article 21. But before I go to that, I just want to get out of the way some of the obvious problems. I don't want to delve into that in detail. We can, of course, pick up those issues during discussion time, but just picking up some of the key issues here. Now, I'm looking at Section 499. 499 says, whoever by words, either spoken or intended to be read, by signs, by visual representation, makes, publishes any imputation concerning any person intending to harm or knowing to have reason to believe that such imputation will harm the reputation of such person is said, except in the cases hereinafter accepted, to defame that person. There are some explanation given, explanation 1, 2, 3, 4, and I will just go through the explanation very quickly. So explanation 1 is in relation to defamation of a deceased person. It says it may amount, and it's in quotation, it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living and is intended to be hurtful to the feelings of his family or other near relatives. Now, just 2 points I want to raise about this, or maybe 3. One, I found that in Subramaniaswamy case, the explanation which says protects the reputation, the words here says, if it is intended to be hurtful to the feelings of his family or other near relatives, to deceased person's family or other near relatives. There's a hurt to the feelings. Now, hurt to the feelings has been equated with the word reputation, according to Subramaniaswamy. Now, and why that's problematic, we'll look at it when we're looking at the definition of reputation as such. But for the minute, the point that I want to make is that this kind of, which is a repetitive process that I see in the judgment. When you're talking about reputation, it is not quite clear what is meant by reputation. This is this mystery word because there's been no definition that has been given for reputation in common law. So the way that the courts tend to deal with it is to try and take snippets and extracts from various sources. So for instance, in Subramaniaswamy, it takes snippets from the Bhagavad Gita, from the Bible, from the Quran, and where they use the word honor. And then it takes from Shakespearean works, wherein it also raises the issue of honor. And very abruptly, it talks about the issue of dignity. So what is it that we are talking about? Is it dignity? Is it honor? Is honor and dignity the same thing? Would that equate to reputation? This is something which I will come back to. But anyway, in relation to reputation of dead person, we're effectively equating the hurt feelings also to reputation, and potentially reputation could be honor, or maybe it is dignity. This is a problem that I think is the key problem in relation to this discussion. Anyway, back to my point. So a deceased person, effectively, defamation can be imputation of anything to a deceased person which would harm the reputation if the person was living. This is pretty strange, actually, because, for instance, what the problem with this particular provision could be that, you can end up with trying to assert a legacy of a person, which maybe they don't necessarily deserve, simply because the person at the time that he was living was able to affect public opinion in a specific way. And once he is dead, you can simply use the defamation principles to ensure that, or family members can effectively use it to ensure that the criticism that is due to him can actually be suppressed. Why? Because when we're talking about the criticism, you're not actually referring to anything. You don't have to really prove anything. You're effectively saying that the imputation just need to be that any person who intends to harm or have reason to believe that harm can be caused. That's the only requirement. You don't have to show that actually harm was caused. So you effectively can more or less say something which is considered to be defamatory, and that in itself can result in this in a case being filed under criminal defamation. And you don't really want to protect the legacy of a person if the person don't deserve it. Now, I'm thinking of a couple of examples from Britain. I have to think more carefully to find examples from India. I don't follow the Indian the news as closely as I do follow the UK ones. So, for instance, a very good example of this would be, I'm not sure if you may be familiar with it, the Jimmy Savile case. Now, Jimmy Savile was is Britain's one of the most prolific pedophile ever, and he, at the time that he was living, nobody dared raise the issue of pedophile charges against him because of the fact that they were too concerned that of him slapping libel cases against them. Now, mind you, we don't even have criminal defamation. This is just in relation to civil defamation, and even so, this was something that practically anybody, even when the police were interviewing him, they dare not speak to him, but in the most polite fashion. He was far too powerful for people to raise any charges against him. The establishment protected him very closely, and even when BBC had actually filed a documentary, they created a documentary about many charges of him and his pedophilic action. They dare not actually air it because of the kind of power that he held at one point. It was only after he passed away that people dared speak about it. All the most worst cases of the things that he did, because he abused hundreds of children, even in hospital beds. They came out only after his death. So what effectively you're talking about is that if you're saying that defamation laws and criminal defamation laws can effectively be used even after the person died, just because it can cause the hurtful feelings to the family members, unless the truth is shown to be for public good, then it's possible that you can potentially continue to maintain legacies such as Jimmy Savile's. Similar case of also Robert Maxwell. Robert Maxwell, of course, you might be familiar with him more because the current case of his daughter, Ghislaine Maxwell, and Jeffrey Epstein's case. But Robert Maxwell, her father, was also found to have stolen money from the Mirror Group, which is a newspaper publication. He was stealing money from the pension fund. In fact, the British government had to then pay into the pension fund in order to support people. But at the time that he was alive, no one dared actually raise any questions or case in relation to him. So anyway, the point I'm trying to make really is about the reputation of dead person, and the fact that it is written so broadly and not in any narrow fashion potentially has is something which must be looked into. Then the another aspect, of course, is the issue about the corporations and criminal defamation, which I already mentioned. So can criminal law of defamation be invoked by corporations? Yes, of course, it can be invoked by corporations, and generally they tend to invoke it. In fact, it's a very widely written sentence. It says that it may amount to defamation to make an imputation concerning a company or an association or a collection of persons as such. So effectively, you have the might of the corporation, which can file defamation cases against maybe citizen journalist, maybe someone who writes about something that the corporation has done in relation to, I don't know, environmental harms, for instance, like in the case of Priya Pillai. Now, the interesting cases that I can think of in relation to this, and again, I need to look more deeply into the Indian jurisprudence. I haven't had the time to do that yet because it's only not too long since I started the topic, is the case of Steele and Morris. It's a McDonald case where they had stopped in front of the restaurant, McDonald's, and they had been distributing flyers, and effectively what they stating that charging McDonald's with doing whatever environmental damages that they were doing and so on and so forth. Case was filed by McDonald's against these two individuals who are literally like normal citizens. The case went on for about 9 years, and effectively what the court held was that, I mean, the individuals had to fight the case themselves because they did not have the money, the wherewithal to appoint lawyers to fight the case for them. They fought the case themselves. Many of the charges they were able to prove was that they were not liable for it. Still, some charges were upheld. They were asked to pay damages of about 40,000. McDonald didn't actually collect the money, but when it did go to the European court, effectively what they found, what they held was that the balance of power, the difference in the balance of power actually invoked issues about right to fair trial. The restaurant, with its powerful lawyers, were able to obtain paperwork as quickly as possible. These two individuals who had no money were able to get the paperwork much later. They could not employ adequate legal expertise, so on and so forth. Raises issues of right to fair trial, raises issues of Article 21, not Article 21 with respect to, if you're trying to use that case in correspondence with the Indian legislation, then it would potentially raise issues of Article 21 and so on and so forth. So the point I'm trying to make here is that if you have a powerful company trying to file a case of criminal defamation against individuals, then clearly it shuts down, freezes free speech, it freezes issues where it is really important for people to know about any potential problems that these companies might be engaging in. What else do I want to mention? Oh yeah, the harm concept. The harm concept is also important. I mentioned it briefly earlier on. Basically, it says that the section only talks about that there must be proof that the person was intending to harm or knowing or having reason to believe that such imputation of harm will occur. But in the, I think it was the Dearmeyer case, was a state of West Bengal 2010 case. It was held that it would be sufficient to show that the accused intended or knew or had reason to believe that the imputation made by him would harm the reputation of the complainant, irrespective of whether the complainant actually suffered directly or indirectly from the imputation alleged. So you don't really need to show that harm, there need to be no proof that harm had actually occurred. Literally, you can, the fact that the person who did the imputation knew or had cause to know that harm would occur is sufficient to trigger section 499. Now, this financial loss aspect is pretty interesting as well, because I was trying to just Google up actually the kind of money that people were looking for with respect to these cases. So for instance, I came across just on Google actually that there was a case of Amit Shah's son. He was claiming 100 crores damages plus criminal defamation. There was Cyrus Mistry was asked to pay 500 crores, or he was being charged with 500 crores plus criminal defamation, and so on and so forth. But interestingly, if you're not looking at these big short figures, I did come across a very interesting case in the Andhra Pradesh High Court. Gorantla Venkateshwaralu versus Demuda. It's a 2002 case reported AR 2003. where this was in relation to a bank manager who was asked to go and monitor some work in a particular society associated with the bank, and the people in the society had written to and also spread the news to the chairman of the Central Bank of India, stating that this particular bank manager was engaging in all sorts of sexual dalliance with various staff members in the society, various ladies in society, in the particular bank society, and so on and so forth. And the person had filed a case wherein he had asked for 20,000 rupees. And the judge had determined that the person was due 15,000 rupees, mainly because this was not only a case of defamation, but there was also aggravating reasons. The whole imputation was false. The other person who was making this imputation had refused to apologize. They were pretty rude about the way they had engaged with the other person, and so on and so forth. So given these aggravating reasons, the court had decided that the person should pay in 15,000 rupees. Now, Andhra Pradesh court cited Salmon versus Houston's law of torts when they refer to, the question about the sum which is being awarded. And basically what the court pointed out was that the sum awarded by should be sufficient to convince a bystander of the baselessness of the charge. So in effect, what you're stating is that the third person, once again, I'm coming back to the point of what is being affected here. It is your reputation with respect to a third person. So as long as a bystander is convinced about the baselessness of a charge, then because of the sum awarded, that would be sufficient. And that kind of reminds me, if I am not wrong, the Reynolds case, which is quoted very often in the Indian judgments, the Reynolds defense, wherein they had given guidelines for responsible journalism. This was a case which was filed by the Taoiseach of Ireland. The Taoiseach is a prime minister. So the prime minister had filed this case. The Taoiseach had filed the case, effectively stating against a newspaper in England, because he stated that a particular newspaper piece did not contain certain. The issues that they had written were actually true, but it did not contain the contextual information which would have given the right picture about him in respect to something. And the case, if I am not mistaken, the person was awarded 1p as damages. So when the reason I'm talking about this is we're talking about the issue of financial loss. Why are we paying the amount we are paying? On what basis are people asking for charges such as, for instance, 100 crores, 500 crores? The recent one that I saw was the Priya Remini versus M.K. Akbar's case, where I think it was also a 100 crore something defamation case, wherein Priya Remini was looking to apply the truth defense, if I understand it correctly. But of course, she needs to prove not just truth, but also that it's for the public good. And that kind of got me interested in the anonymity issue as well, with respect to these people who are charged with rape allegations. So it used to be the case in the UK that the people who are charged with rape allegations, effectively, there was no anonymity for them. At some point, because there was quite a lot of discussion, debate, lobbying, stating that it is unfair that a person who has been just facing allegations, not even charges, his name should be out in the public. It affects their reputation, harms them, and so on and so forth. At one point, they had come up with a legislation stating that anonymity will be provided. But then within 10 years or so, they lifted that. The reason that was given was to state that where a rape allegation is being made against somebody, society benefits because the anonymity is not given because other people who have not yet come forth with the allegation will also come forth with the allegation because it was simply to get other people or to give confidence to other women to identify this person and come forth and substantiate charges from their perspective. So in the case of Priya Remini, if you see, for instance, it's something very similar that had happened. She had written about some experience that she had with MK Akbar. More or less after her experience was published online, you saw a whole series of other people who had experiences with MK Akbar also coming up. And this was actually not even a rape allegation. This was simply a case of sexual misconduct of some nature. Anyway, the point I was actually trying to make, and I'm really digressing here, is about the case of financial loss. How do we even determine financial loss? Why is it that some person it's okay for some person to receive 15,000 rupees or 1 pence, and for other persons we are talking about loss in the range of 100 crores, 500 crores, and so on and so forth. And I will come back to that point again when I discuss the issue of reputation. So this is a point I will come back to. But before I go to the final point, which is where I really want to criticize the judgment. Another point, and I've lost my train of thought. There was one more issue I wanted to raise before I go. I totally lost my train of thought. So harm principle. Right, I think I'll have to come back to it if I remember. But I will come to the issue of reputation. So yes. So in effect, you have a situation wherein if somebody has made an imputation, you can rely on the protection of Article 19 if you show truth, not just truth, but in addition to truth, you have to show public good. If you look at further explanations, which is given in the section 499, and I'm not going to go into the details of it, we will also see the application of, for instance, good faith. At some point, the court had tried to make distinction between good faith, stating that the good faith clause is different from the truth clause, but the way the good faith has been defined in some of the case law indicate that the person, when he's making whatever imputation that he's making or causing a particular injury with his imputation, has actually taken into regard the question of truth. So anyway, the point is that in order to obtain the protection of the freedom of speech and expression, you need to show truth plus public good, maybe good faith plus public good, and so on and so forth. Now, once you show all of that, then literally you stand under the umbrella of protection of Article 19. And once you have that, what the courts have effectively tried to do is to say that, right, you come here with the protection of Article 19. However, I'm going to place you in opposition with someone who's claiming reputation under Article 21. Then, like in the case of Puttaswamy and so on and so forth, where they talk about the balancing of issues, literally you're saying that when you have this conflict that comes into effect, Article 19 with Article 21, despite the fact that you have already shown truth plus public good, good faith plus public good, which has been interpreted as public interest already, even though we have shown all of that in order to gain the protection of Article 19, we are going to ask you once again to show public interest under Article 21, because the protection given for reputation is equal to, or maybe higher, to the protection given for the freedom of speech and expression. And if there is a clash, the clash can only be dealt with, or for instance, a harmonious interpretation, maybe you deal with it by looking into public interest in the context of reputation. So you already shown good faith and public interest and so on and so forth, but now you once again show it within the context of reputation. So literally what you're having is too many steps to jump, too many hoops to jump through in order to state that your right to freedom of speech is should be protected as opposed to the protection that is being given for reputation under Article 21. And mind you, I'm only talking about criminal defamation. I'm not necessarily saying that defamation, reputation should not be protected. Of course, reputation should be protected, but reputation should be protected through the use of civil cases as opposed to the use of criminal cases. That's the distinction I'm trying to make. So there is, I'm not a free speech libertarian here. Of course, free speech is not absolute. None of the fundamental rights are absolute. There needs to be some sort of restriction that is given to it. But the point is merely the fact that instead of using criminal defamation, why not use civil defamation principles? Now, why? Why would the court want to use or give this veneer, this heavy protection of reputation under Article 21? And this is where I go into the definition of Article 21 as given by the courts. Now, I look at the definition, and I mentioned this already. As stated in Subramanian, and more or less this exact same thing that I see in the other judgments as well. When you're talking about reputation, the code does not make it clear as to what is meant by reputation. The common law does not give a definition for reputation. And so in effect, the code takes or lifts various extracts, wherein the usage of the reputation is being associated with completely different concepts. So for instance, in some cases, defamation is being treated as a property. In other cases, defamation is being treated as honor. And in other cases, defamation is being treated as dignity. These are completely different things. But the way the judgment is written, they seem to be intermingled with one another in a very seamless fashion. And that creates quite a lot of issues here, because if you're going to treat reputation as a property, it's very different from treating reputation as dignity, and also very different from treating reputation as an honor. If you're treating it as a property, so this is the kind of goodwill. The person does something in society in order to gain his reputation. There's something that he is doing in order to obtain the goodwill that he obtains. We can see that with corporations, for instance, especially passing off and so on. They do some work which allows them to engage or obtain a standing in society. That standing is recognized by third parties, and that's how the legislation is written. The third person, the estimation of the third person, you have gained something, and if any loss has occurred to that particular aspect of your reputation, then of course that loss needs to be compensated. So when you're talking about compensation, you say, okay, what is the loss that has occurred to me? You compensate me for that loss that has occurred to me, to put me in the right, put me in the position which I was before I was defamed. So that is one aspect. So you're treating literally reputation as property. But if you treat reputation as honor, you're coming into completely different grounds altogether. Because reputation as honor is something which was acceptable in pre-industrial England. Because when we are talking about the issue of honor, this is the ancient tradition which views the worth of reputation as, you're not looking at it like a marketplace, which is what is happening in the case of when you're treating reputation as property, because it's a marketplace of ideas kind of stuff. That's not how you see it. So for instance, if you look at the Bible, which talks about a good name is something that is rather to be chosen than great riches. When you're talking about Shakespeare, talking about a purse is just a trash, and when it's compared to the good name of a person, and so on. So this, the strand of this tradition is influenced in pre-industrial England. And the view is that the reputation is a form of honor, and the concept of honor has many aspects. But the kind of honor that is really important for the development of defamation law may be defined as a form of reputation in which the individual's personality identifies with certain normative characteristics in a particular social role. And in return, personally, he receives from others the regard and estimation that society accords to that role. So for instance, a king, he is accorded that role by the people. For instance, in the current day society, we can see that in India, a case of caste, an upper caste. They see themselves in a very stratified society wherein a certain individual is somehow perceived to be more important and therefore expects or assumes that he has a certain honor or a certain reputation which ought to be protected. And this was something that was also recognized by the Supreme Court. I can't remember the name of the case at the top of my head, where they did lay down guidelines in relation to the issue of honor killing, wherein the court stated effectively that honor killing, reputation is based on the reputation of a woman, which is in this patriarchal society, it's a social evil that needs to be dealt with. This is a very artificial way of looking at reputation as such, and so on and so forth, because effectively you're treating society as a stratified organ. And in this stratified organ, you're effectively stating that you're accepting the role of superordination and subordination. And effectively you're placing yourself in a particular social role wherein you are given some sort of an esteem by the rest of the people who don't have that particular honor that you have. Treating reputation as an honor in this day and age is pretty strange, especially if you look at honor as a way in which you retain this system of stratification, wherein even distribution of wealth is done within a social idiom, and there are prescribed appropriate behaviors, which, for instance, different caste may have for one another, and so on. I'm not necessarily pitting the upper caste versus the scheduled caste, scheduled tribes. For instance, you can also see within these riot killings and so on and so forth, wherein scheduled caste women has married someone from the scheduled tribe, and that creates an issue of honor, that creates an issue of reputational downfall for that community, and so on and so forth. So when we look at reputation as an honor, that has a completely different connotation from treating reputation as a property. Wherein you're saying that, okay, my property has been affected, my reputation has been affected, you make good that what has been affected. Then we come to the issue of dignity, and this is my final point, and of course there are many other issues, but I think we will leave that for discussion. When we are talking about dignity, what is it that we are referring to? So let me look at, there is a definition Yeah, this was basically Justice Stewart's opinion in Rosenblatt versus Bayer, something which is actually used in the Indian jurisprudence as well. The right of a man to protect his own reputation from unjustified invasion and wrongful hurt reflects no more than our basic concept of essential dignity and worth of every human being, a concept at the root of any decent system of ordered liberty. The protection of private personality, like the protection of life itself, is left primarily to individual state, but that doesn't mean it is not as important and so on. Now, the important words that we pick out from there is, it's pretty much a paradox. So you're talking about essential dignity, and you're also talking about a person's private personality. Now, so if you're talking about a common or a general estimate of a person can affect the essential dignity of a person, you are placing the idea of dignity within two different contexts. So dignity, when your dignity is affected, it is your personal worth, your personal integrity, your personal a person's personality that is being affected, and you're pitting it against dignity within a social sphere. When you're talking about the question of common or a general estimate of a person, a common or a general estimate of a person by a third person, which is how we see it already, I mentioned in section 499. So literally, you have to find some sort of a connection between this public sphere and the private sphere. And we can look at sociologists to find this connection. So effectively, where I think it was Mead who comes up with this theory, wherein you're stating that a person is at every point in time joining hands with another person in the society, wherein he is engaging in rules of deference and demeanor, thereby has to apply rules of civility in order to ensure that he becomes part of a social sphere. And in effect, at any point in time, if someone breaks this rule of civility through his demeanor, through his lack of deference, for instance, through imputations, defamation, so on and so forth, you break this chain that you have effectively created. And once this chain has been broken, then of course it needs to be vindicated. The person whose dignity has been affected then becomes not a complete person, because his standing in society has actually been affected through this breakage of the chain. And therefore, to put the person back in place, you need to vindicate the person's presence, bring him back to what he was. And to do so, you don't treat dignity as, for instance, property, wherein you're compensating. You're not looking at compensation, you're looking at vindication. And the vindication of a person can basically take place if the court is effectively stating that I find that this defamatory imputations that has been made against you is false. That would be sufficient by itself. It is not necessary to compensate a person when you are trying to treat it as a question of dignity. Similarly, you are not trying to, you're not looking at it from an issue of honor either. Because when you're talking about the issue of honor, you're literally, you're asking for a person's honor to be re-established within that particular society. It's very, very different because you're asking for a vindication of honor as opposed to a rehabilitation of dignity. So you're talking about three different societies as such. So if you're treating the society as a marketplace, the society as a marketplace literally would mean that you're treating reputation as a property. But if you're looking at the society as a deference society, then you're treating it as a case of a reputation as an honor, where honor is treated as a public good. And if you're treating society as a communitarian society, wherein you're looking at issue of dignity, what you're looking for is merely an issue of rehabilitation. And if it's merely an issue of rehabilitation, the rehabilitation does not have to happen through depriving a person of liberty by placing him in jail. That's my point. So you're not necessarily, so when you're exercising your Article 19, the fact that you're exercising, when the point that you're exercising Article 19, you're also exercising your right to life and personal liberty through this sphere of freedom of speech and expression. So you're not necessarily pitting Article 19 against Article 21. What you're doing instead is pitting Article 19 in combination with Article 21 against Article 21. That's what you're trying to do. So if that is the case, it's not a case of Article 19 versus Article 21. It's Article 19 plus Article 21 against Article 21. But if you look at the issue of, for instance, the treatment of dignity in the, like the Section 377 case, you're talking about the most vulnerable sections of society, wherein you're saying that their dignity has been affected, and that dignity which you protect under Article 21 is literally in combination with Article 14, in combination with Article 15, prohibition of discrimination, so on and so forth, which is not the case that we see with respect to reputation. Because with respect to reputation, it's actually the people who are filing the case or we don't necessarily associate them with this vulnerable section of society who, it may be the politician, it may be a celebrity, it may be the corporation and so on and so forth. They are not there because of issues of equality or because of issues of discrimination, as we see, for instance, when we are looking at the issue of dignity with respect to the way it was treated in Navtej. So in effect, what I'm trying to say is that this is an artificial construct that has been created. And the artificial construct that has been created by the court is because of the fact that they have not drawn the differences or clear nuances between the type of concept that we are protecting when we are using the word reputation. There is no clarity in the concept. You're simply using the word defamation in association with dignity, in association with honor, in association with property. It's just a very loosely constructed definition, which has created this artificial problem wherein we are expected to pit Article 19 against Article 21. What the courts really need to do is to draw out what exactly is being protected in accordance with the sections of Section 499 and so on. Or on the other hand, the alternative is to say that Section 499, to test the presumption of constitutionality of Section 499 as a pre-constitutional legislation. So there are two ways in which the court can potentially go about it, but literally the idea is that criminal defamation as such is not the solution to treat the issue of reputation. Reputation can be protected by civil defamation, and one slightly sad aspect with respect to the judgments in the Indian jurisprudence is that generally Indian jurisprudence tends to be the leader, is the one which is leading with all sorts of new innovative ways, creative ways to protect the the vulnerable in society. But what we are actually seeing in current day is that judgments from countries that obtained its independence far later than India, such as, for instance, Zimbabwe and so on, the courts there have already found criminal defamation to be arbitrary, to be excessive, to be something that ought not to be used in order to protect reputation, even though they have exactly similar provisions. They also have the same colonial provisions. We see Kenya, we see Lesotho, we see Jamaica, for instance. They abolished not only criminal defamation, they seditious libel, all sorts of libel they abolished. So effectively you're saying, I'm not just talking about the UK and so on, where it was already abolished. I'm talking about other jurisdictions as well, where they are leading the way already. And I think it's time that India should follow suit.
Thank you, Sujitha, for that wonderful presentation. And before you face the firing squad, can I just articulate? I mean, what I could understand of the presentation was that free speech expression is all right, right? But
yeah,
it should be visited with only civil consequences, but
yeah,
not criminal consequences.
Yeah.
Yeah, essentially, well, that's what he said. Yes.
I hope that the quintessence of what your presentation is.
Yes.
And in the sense like, and you did have a very good ecosystem like Singapore and UK, which is less than a state or a half a state of India, where you did your investigation, your enquiries or whatever it is. But when it comes to India, I don't know. But before I come to Justice Jayasankaran Nambiar, I would like to have the comments of Ramkumar sir.
See, first of all, if criminal defamation ceases to be a reasonable restriction on the right to free speech, Justice Jayasankaran Nambiar has already given the competing fundamental right of reputation as enunciated in Puttaswamy. Then what about the other right flowing from Article 21 about the right, about the crime-free environment, the right to reside in a crime-free environment? Is it not a right flowing from Article 21? You have got a right, a fundamental right of residence in a crime-free state. Even that is violated. Then reputation, according to me, is can be dignity, integrity, even what do you call good character or honor, everything, and even a what should I say, a right not to be humiliated, a right not to suffer any ignominy, etc. And one single largest person who indulges in attack on reputation is the media in our country. They indulge in criminal defamation only. See, even an accused person is entitled to reputation. He has reputation. He is insulated by the presumption of innocence, which has been elevated by the Supreme Court of India to the level of human right. It has been elevated to a human right. Even a person accused of an offense is having reputation, human rights, etc. And what is it that is what we see in the media very often, especially after 10:30, you find some crime story, kuttapatram, charge sheet, etc., wherein an FIR is registered against persons, maybe rape, maybe murder, maybe some other offense. Just because an FIR is registered, is he to be characterized as a most despicable person? He has the presumption of innocence. Unfortunately, media doesn't apply that. While it is applicable to courts in our country, the media doesn't have this presumption of innocence, and therefore a person is defamed. And ultimately, if the court acquits him, by that time a parallel media trial is conducted, and if ultimately the court acquits him for want of legal evidence, even motives are attributed to the court, to the judge. This is the environment in which we are living. And see, we had two Maldivian ladies by name Mariam Rashida, Fasia Hussain. They were dubbed as sex bombs by the media in our country. And they went back to Sri Lanka after being cabined, cribbed and confined, even imprisoned. And ultimately they got liberated by the courts. And they went back to Sri Lanka in utter humiliation. You see, the ignominy they suffered, these ladies suffered. And what about Nambi Narayanan, a great scientist in the ISRO? What was his thing? And can anybody who is defamed by the media, can he fight the mighty media by filing cases, by filing prosecutions?
Sir,
Let us not.
Mighty media is identifiable. What about this? Somebody who want to hide behind anonymity?
Yes, exactly. That is what. Therefore, in my humble view, in fact, constitution makers they have very guardedly used the word defamation also, and not civil criminal alone, both civil and criminal. They use the word only defamation. According to me, that is it has a very rightful place in Article 19(2).
Sir, there again, if I may, add something. This civil thing depends upon damages.
Yes. And
if somebody makes an allegation who has got no wherewithal, are you to suffer it?
Exactly. And you will have to prove that you have a reputation. And you will have to prove that you have a reputation. In fact, reputation is a matter which is presumed. A person is presumed to have a reputation, even an accused person accused of an offense. And he will have to prove that he has a reputation. His reputation was violated, etc. Let us not be so impractical. Sorry, subject to Mr. Jayasankaran Nambiar's view.
We just hear Ramashan sir also before we go to Jayasankaran sir.
Okay.
Madam, you have really made an attempt as an academician and also research scholar to go into the question of categorizing defamation as a civil liability alone. See, madam, if you go by the tortious principle, even all the acts done against a property can be compensated by money. See, for theft, it is a conversion of one's property to another for their benefit, causing loss. Why should be a criminal liability? It can be made good by paying compensation. So sometimes something may be required for the purpose of protecting the society against crime. So probably, as my brother Ramkumar has said, a mighty person making imputations against the honor of a person or affecting the reputation of a person, then if you go with the principle of compensation alone, he will pay the compensation, repeat the same thing. If there is no criminal liability fastened on him to threaten or deter him from repeating such things in future, and also to give a message to the people that if such things are done, you are not only civilly liable to pay compensation, but also you are liable to be imprisoned for the offense committed. So it is on that aspect, probably in that view, considering the Indian condition, probably the legislature thought, the constitution makers thought that the loss of reputation is to be taken care of as part of right to life as enshrined in Article 21 of the Constitution. Probably that may be the reason why criminal defamation has been, the defamation has become a criminal offense. And according to us, whatever be the manner in which you have said that dignity is different, honor is different, and property is different, ultimately, if you combine all together, it will amount to a right to property as such, because honor itself is a right. If that be the case, any loss has been caused to the property, then automatically, because some are tangible property, some are intangible property. Reputation may be in the possession of an intangible property, where you can say that the right has been affected, you are liable to be prosecuted for that offense. Probably in foreign countries, they mainly dealing with the seditious libel against the state, as taking as a war against the state. That also you say in some countries it has been abolished. I do not know why, because that depends upon the will of the people there, and also that is being respected by the respective countries. But as far as India is concerned, I think that the scenarios explained by Justice Ramkumar, unless some guard is provided for the purpose of protecting the society as such against such irresponsible activities by some people, it may affect the reputation of a person. Reputation doesn't mean financial loss only, because a person has got reputation. If it is affected, it is not only affect his in person, but also sometimes it may carry to the reputation of the family also sometimes. So if in the larger perspectives, I think that the Subramanian Swamy's case, the Supreme Court has correctly come to the conclusion that it has to be decriminalization of the defamation is not warranted. Subject to what Nambiar is going to say.
Thank you very much. Thank you very much. Before we come to Jayasankaran sir, I hope if it's only comments, can Mankumar sir and Haidar sir just make that comment in a very short statement.
Hello. Hello.
Yeah, I mean, you're audible.
Okay. Madam.
No.
In India,
you address the issue, not the
person. Okay. In India, a civil action for defamation is a cumbersome procedure. One has to pay heavy court fees beyond his affordable limits. And you also remarked about the quantum of compensation. If compensation is just a few rupees, anybody who defames the other can pay off and walk away. And he can repeat the same act of defamation in any other form. At the same time, one who is defamed has to bear the burden of paying heavy compensation. He has to do it with a hard burden. As you also know that the good name in a man or a woman is the jewel of his or her soul. It is that I'm referring the off-quoted.
Sir.
Saying in Shakespeare. I'm coming to that. That is. Its reputation is also an intangible property. One who steals it has to pay compensation in the
Then again, you are subscribing to the view that it's only compensation. Wonderful.
No, not compensation. No, I'm not saying compensation is in addition to the criminal action. That is what I am saying.
So somebody should be inside the bar and should pay compensation as well.
What?
Somebody should be inside the bar and should.
Exactly. Because that is why the restriction was drawn in Subramanian Swamy's case. Because it's a pre-constitutional law of defamation. The criminal defamation is a pre-constitutional law that continues even after the Constitution. Just because that the Constitution framers also decided to keep it as a criminal offense.
Wonderful, sir. Wonderful. 1 second. Haidar sir, can you just...
Yes, I said. I am on... I have one point I have to clarify. 1 second, sir. Can you bear with me?
We have been...
Yes. The question section, we have taboo under section, sir. Lot of judges are here. Ramkumar sir, he is one. We have a taboo under section 199 of the CRPC. Because suppose a person calling me Haridas is a thief. Sir, can you hear me?
Should I call it Haridas?
Yes. Haridas is thief, or my wife is also.
Okay, sir. Please go ahead.
The question: Why have to file a complaint? Now we have police act, sir. Now lot of cases are coming now. Just I want to have an interaction with Dr. Sujitha Subramanian. We have 499. It is an offense. I'm on the criminal law on this, especially on this part. We have 118A of the Police Act. The Prime Minister is a thief. Lot of comments are coming.
Yeah.
The question: why we have? What is the hindrance for the legislation to amend Section 199?
Oh. Logic question is coming.
That is even commoner should be treated on par with the constitutional functionaries. according to you.
Absolutely, absolutely.
Even a common man should be treated on par with a constitutional functionary who is defamed.
Probably he may be thinking that instead of a private complaint being filed, identifying the person, he can go for the police and file make a complaint. So that can be registered.
He wants this public prosecutor to file a complaint before the session.
That is with respect to ministers and all. 102. The question, somebody called me, Haridas is a thief or my I have not theft something. The question, why? Because section 2D CRPC we have. A person can file a complaint. What is complaint? So I have to, police cannot take a case. Now we have section 118E of the Kerala Police Act.
Yes.
That's why a lot of issues are there. Some WhatsApp messages are because in 1973 when this CRPC's B motor 190 is added, there was no digital evidence, there was no WhatsApp, there was no email and all. At the same time, defamation question, suppose the recent Sopana case, how it is right through this some ministers and all. One minister even personally contacted me today. What is the portion? I think even in Bangalore I had a discussion on it. So 199, it is the madam was telling, it's the taboo, like Ramkumar sir was telling again and again.
Sir, let us just frame the question. What exactly is the issue?
My issue is that because of the development of this digital media, electronic evidence, etc., law of defamation, as far as law of defamation is concerned, this section 199 has to be amended.
That's the point you want to make.
To some extent that, because sir, 118E, we have 118E, that's why I'm not pointing anybody else. Somebody telling that some the ministers and all done something.
What about, let us consider the issue. What the persons like
Haridas, 118E is Police Act.
The issue.
Police Act is just noted because defamation, my reputation is affected.
All right.
That's why somebody called me, I am a thief. Not done. Now, the Police Act, it is not exhaustive. Somebody is registering a case because I have a lot of occasions, thousands of cases are with me. Just because the Prime Minister is a thief, Chief Minister is a thief. No. The question 199, we have at the same time, sir, we had section 66A, especially I'm not on the IPC or the civil law.
That is quashed.
66A was there. It is quashed a single case. I have all the notes are with me. The question 199, when a progressive legislation is being mooted, after the introduction of lot of issues are there. So somebody, because how to protect the dignity? I have dignity. Even if a thief, even if a prostitute, I have dignity.
All right.
Yes, that's why somebody telling that Haridas is a prostitute.
So why do you want to amend 199? In what way?
To some extent that I can lodge a complaint before the police. The police can. Sir, is it the right way? I don't know whether it is because a lot of
you want the offense to be made cognizable.
Cognizable. It should be cognizable because a lot of restrictions are there. 198 is there, 199, 195. What about 188, sir?
Now, forget about that. You come concentrate on defamation. Right to free speech.
Free space. I have to file because I can go to the police. I can lodge a complaint. The police cannot. Even if the police registered a complaint, registered an FIR, suppose that after investigation filed a report stating that my reputation is muted, something, it is mutilated. But what will be the effect? An application can be filed either under discharge or 258 we have.
Okay.
My point is that section 199, in the light of this present, especially WhatsApp, this email, TV, news, everything. So section 199, some amendment to section 199 is needed. That is my point.
Okay.
Fine. That point is well taken. And now
thank you.
Let's go back to Jayasankaran Nambiar, sir.
Sujitha, congratulations. You covered a lot of ground and admirably. I know that there is a lot left to be said, which you could not say because of the time constraint. But I think within that limited span of time, you covered quite a bit. I just have a few observations. It's not necessarily a question to you, and I don't expect an answer from you. I just wanted to give you some of my observations in the peculiar context in which we are situated in India. You did use a lot of examples from the British common law, and in the light of the definitions that you have in the criminal law in Britain with regard to defamation, etc. The point of distinction between the UK law and the Indian law, as I see it, is that UK does not have a written constitution as we do, and therefore we have certain principles which emanate on a higher plane, and our interpretation of these statutory provisions in India always tend to get a flavor imparted to that from the constitutional principles. Now, when it comes to defamation itself as a subject, you must understand that under Article 19(2), defamation is a subject which is specifically mentioned in the Constitution under Article 19(2) as an area where you can impose a reasonable restriction to the exercise of the freedom of speech and expression under Article 19(1)(a). What that translates into is, if you make a law relating to defamation, that law traces its validity and gets its coverage straight from the Constitution and under Article 19(2). So it has got the source of the interpretation, the source of power there is relatable directly to the Constitution, and you have the legislations which statutory instruments that come thereafter tracing their validity to 19(2). When you talk about, look at the allied subject of, say, contempt of court, for example. Under 19(2), you have a reasonable restriction in the interest of the contempt of court. Free speech cannot go to the extent where it brings to disrepute the majesty of the courts, etc. And therefore, you have a Contempt of Court Act which informs which prescribes certain restraints on the exercise of free speech. We use the Contempt of Court Act for the purposes of punishing persons who resort to a criminal contempt, etc. When it comes to defamation, you have two courses of action. One is a criminal and the other is civil. Now, when it comes to criminal defamation, you're right in your understanding that it is a pre-independence law, and therefore it continued to be in our criminal jurisprudence, in our criminal under our criminal laws even after the Constitution came in. But you should also realize that when we gave to ourselves the Constitution in 1950, privacy was not an aspect of Article 21. Privacy did not feature as a fundamental right under Article 21. In fact, if you read the Constituent Assembly debate, privacy was deliberately excluded, specifically excluded from the ambit of Article 21 of the Constitution. Therefore, I would think that when you're talking about the interpretation of the word reputation, when you're talking about the scope of criminal defamation, etc., till 2018, I would think a large extent of what you mentioned with regard to your concerns regarding the absence of a definition, a clear-cut definition for reputation, what is to be protected, how are we defamed, etc., would be significant. However, I would put the cutoff or the turning point as 2018, when Puttaswamy decided for the first time that the right to privacy is also a fundamental right. It's not as though we did not recognize the right to privacy even earlier. In fact, even from Karat Singh's case, we have right to privacy, initially in the form of a dissenting judgment from Justice Subbarao. Later on, in Govind and other cases, we have it getting into more firm terrain. But Puttaswamy is ultimately what crystallized it into a fundamental right. When we started looking at privacy as a fundamental right, you must understand that privacy is actually dealt with in three different aspects there in Puttaswamy. And you're right about the length of our Supreme Court judgments, which runs into about 1,200 pages. We are all a little concerned about such judgments, but if you do actually crystallize it into the essence, you find that largely privacy that they are talking about is three types of privacy. One is your spatial privacy, which is the right to be left alone. The second is your bodily integrity, which is aspects of your body, personal choices, And that's where dignity and reputation also comes in. The third is, of course, data privacy. And for that, we have specific legislation on the anvil. We still have to bring in data protection laws. But talking about the freedom or to make choices with regard to our bodily integrity, freedom to have our dignity preserved, a right to have our reputation preserved. This is where it comes. Now, that being an integral part of the privacy that is recognized as a fundamental right, after 2018, you have to read this as an integral component of the protection that is offered under 19.2. 19.2, therefore, when you read the Criminal Procedure Code after 2018, the definitions under the Criminal Procedure Code in 499, wherever there is a mention of reputation, wherever there is an aspect of defamation, it has to take its color from the constitutional interpretation of the word privacy. There's no escape from that, because our constitutional, the source or the validation that it gets, the validation that these statutes get from the Constitution through Article 19.2 necessarily means that any interpretation of the provisions of these statutes must get its color from the constitutional interpretation of the word reputation. That's where the catch lies, in my opinion, because you cannot thereafter have a definition of reputation for the purposes of criminal defamation, independent or divorced from a definition of reputation for the purposes of the Constitution. And there, when you're talking about 1921 debate, etc., it's not necessarily a debate, but you need to recognize the right to privacy, whatever that may be. I'm not saying that Puttasamy gives you a rough and ready definition of what reputation is. We still are in an evolving process, and like many other concepts in the Constitution, it is necessarily to evolve over a period of time. It must necessarily undergo a change over a period of time, depending upon changes in society. What you see as your reputation today may not be much of a reputation tomorrow. So these are evolving and changing concepts, and therefore we have to interpret the word reputation as at a given point in time, and the breach of or tarnishing of your reputation must also be viewed in the context of the societal changes that have happened. So I don't think there is an escape from the fact that your interpretation, the criminal defamation cannot now be separated from the constitutional protection granted to a person's reputation. And so long as we have to protect that reputation, you need to have a machinery whereby people are punished for damaging the reputation of the damaging or infringing a fundamental right of the person who is defamed. Now, looking at it from another angle, and this is maybe an answer to the problems posed by Haridas and others. It may be, and I'm just speculating here, maybe in future or the years to come, we could see an advent of compensation being given by the public through a public law remedy in cases like this. For example, and it's not a novel concept. When violations of fundamental rights under Article 21 were noticed in the past, say for example the Bhagalpur blinding case, the Supreme Court did go into the extent of directing a compensation to be paid by the state to the victim. Now, I'm thinking aloud here, and I'm asking in academic interest, what prevents the courts from actually going forward to recognizing a right to a person's reputation being now a fundamental right under Article 21, where there is a breach of that fundamental right? And as I mentioned in the outset, whenever there is a conflict between one man's freedom of speech and the other man's right to fundamental right to reputation, it is the fundamental right to reputation that has to be safeguarded, and the other must give way. Now, in a future case, assuming that there is a tarnishing of that reputation, and there is therefore a breach of that fundamental right, what prevents the courts from directing the state governments the states who are to protect the fundamental rights of the citizens under the Constitution. And when it comes to 21, it's not only citizen, it is of the person itself. So what prevents the courts from directing the state executive to compensate the person whose reputation is gone or whose reputation has been violated, and maybe extracting that money from the person who was responsible for causing damage and reputation? It's not something unthinkable. And I'm only putting this on a theoretical footing as of now, because it's too early days to be exploring these things in court. But if public law remedies can also be thought of now, over and above the remedies that you have in civil law and criminal law. And maybe that would be a solution to the practical problems that are faced by a litigant in getting damages for a loss of reputation. So just some observations that I wanted to make in this connection. Thank you.
Not that I mean, Sunitha, it's not a question of question answer session, but still,
just observation.
Have your thoughts on that. It's wonderful.
Yeah, I was just
2 or 3 minutes.
Yes. So, I mean, I think some of the questions are actually overlapping. So it can
never answer questions. You just have your thoughts on what the perceptions or what do you call thoughts that is expressed. Don't answer them, please.
You should use my strategy and just say, I'm making a few observations.
that
won't attract any opposite view.
Absolutely.
Well, I read somewhere that someone's 4-year-old child said, "Mummy, I want to tell a question." And the mother replied, "Well, you will become a lawyer." So we don't ask questions, we tell questions, but, there we go. Anyway, the point I think that is repeatedly coming out, and I'll start with the last point, which was made about defamation being already mentioned, Article 2. I think everyone mentioned that. One thing that we need to remember is that it is defamation that is mentioned in Article 19.2, not criminal defamation that is mentioned in Article 19.2. So yes, there should be restriction. No one said otherwise. Yes, there should be provision for defamation. No one says otherwise. The point merely is whether or not it should be in the form of a criminal offense. Now, that being the case, several other points were raised. Like, for instance, what about the right of the accused? How do you protect him? What about the right to live in a crime-free society? So on and so forth. In all of these questions, what I see is that you're treating the accused always as a victim.
Sunitha, can I just add to your agony?
Go on.
Please, Prem, your comments on.
Sorry?
So that I mean, I'm just asking Prem to have his comments so that let us have a comprehensive, it's not a reply, it's just thoughts. Okay, exchange of thoughts.
Okay, yeah.
Prem, please.
Yeah. Even when the speaker said, I would just say, of course, speech is what you say, the God's gift to mankind. No doubt about that. And it is maybe by way of your speech, you convey your thoughts, your emotions, sentiments, feelings, whatever to others. But your freedom of speech, of course, though it's a natural right of any human being which you acquire on birth, but it cannot be unfettered. See, let me just tell you, you had mentioned about that Priya Pillai's case. Just see the judgment in Priya Pillai's case. And just see the, her special leave petition. Voluminous special leave petition that was dismissed by the apex court merely in 3 sentences. Despite having been granted with a stay, merely in 3 sentences. Now just see the Subramanian Swamy judgment again, which you were referring to. See the fundamental right of speech, that no doubt about that it can be restricted by a duly enacted law The only thing is that it should pass the muster of reasonable restriction, as is contained under Article 19, Clause 2 of the Constitution. Now, I don't know whether you have the occasion to read the judgment in that Pravasi Bhalai versus Union of India. That's a 2014 judgment reported in 2014, volume 11 SCC at page 477. Now, even before that itself, this particular question, even though in a different fashion, had come up before a 7-judge bench in Maneka Gandhi. Justice Bhagwati, who was speaking for himself as well as 2 other great judges, he went on to say that the fundamental rights which are conferred by Part 3 of our Constitution, it is not distinct or mutually exclusive. Each freedom, of course, do have the different dimensions. And merely because, what you say, the limit of interference with one freedom is satisfied, the law which is brought into play, it was not freed of the necessity to meet the challenges of some other guaranteed freedom. Right. Now, kindly see. Long back, one of the first cases which His Lordship Justice Jayasankaran Nambiar first referred was A.K. Gopalan's case, which spanned into several articles, one by one, which was mainly one which related to a preventive detention of 1950 by in the Madras State. And kindly see the minority judgment therein, where it was a 6-judge bench and 5 judges who went against the, who were of the opinion that it was only Article 22 by itself was a watertight compartment. And 20 years thereafter, in R.C. Cooper versus Union of India, 70 Supreme Court decision, it was overturned, which again we see in Maneka Gandhi. See, when you say the defamation, it is not the criminal defamation which is contained in 19 Clause 2. I cannot agree, because even see, let us see, A.K. Gopalan itself. See the judgment of Patanjali Shastri. There, His Lordship goes on to say, man as a rational being, he may decide to do many things, but we are living in a civilized society. Your desire should be controlled with the exercise of other similar desires by other individuals.
Absolutely.
You will have other individuals in the society. So doesn't it need that there should be a balancing of rights? There should be a balancing of rights. Merely whatever you can say. I don't think that it is a farce, I would say. And kindly see, what are the limitations under Article 19 Clause 2? 19 Clause 2 says about so many limitations. Now you have a right, everybody has a right to criticize. True. But the right to criticize or right to say something, that does not mean that you can go against those 8 things which are said in Article 19 Clause 2. If it is against the security of the state, or if it is against what you call the fundamental relations with the foreign state, the public order, which you see, one of the first cases was Ramesh Thapar and Brijbhushan case. Minority, it was based upon the minority judgment of Justice Fazal Ali. The first constitutional amendment itself comes. You can refer to those judgments. The first constitutional amendment, mind you, that came from the dissent of Fazal Ali in Ramesh Thapar and Brijbhushan. And then, of course, you have the contempt of court. What do you say? If you go and say anything against the judges, just see EMS Namboodiripat's case of 1970. See, Parashar versus Farooq Abdullah, that's an 84 Supreme Court decision. Then how would you say the defamation would not come? Even I would say an incitement for an offense. That is what the first amendment to the Constitution says. Even an incitement to an offense. Isn't it? So I would say free speech, of course. Free speech, of course, it is a much cherished right. But something, because there is a boundary line for the free speech. You cannot transgress your limits, saying that anything I can do, anything I can say. That is not the proper manner. There should be something, because I may be excused to say, now, even if it is madness, there should be some method.
Prem, can I just...
Definitely, sir. Definitely, sir.
No, just seeking permission of all of you, because I just need to leave. I've got an appointment at 6. So if I'm so sorry, I don't mean to be rude.
No, absolutely no issue. Yeah.
Please forgive me. And Sujitha,
Thank you ever so much. Thank you for joining. Thank you for your comments.
Thank you for the wonderful time. Prem, sorry I interrupted you.
No problem.
To all the others also.
Thank you.
I'm sorry, because I just have to go for this. Thank you.
Thank you.
Thank you.
So, madam,
Let's continue.
let me just confine myself to this thing. See, the only question is, what are the grounds to which your freedom of speech can be restricted? That is a bare minimal question which you can pose. Article 19(1)(a) grants you the freedom. And see the restrictions under 19 clause 2. Now, what are your main elements of freedom of speech? Kindly see, the freedom of speech, it is a right which is available only to a citizen. Is it available to a non-citizen? No. Now, Article 19(1)(a), your right to speech means you can express your view or opinion through any medium, maybe by mouth or writing, printing, film, movie, anything. See, but the government can always frame the laws or impose any reasonable restriction in the interest of the sovereignty and integrity of India, or see the security of the state. And all the, all the eight examples, 8 things which it is beautifully dealt with under Article 19 clause 2. And over the years, kindly see the judicial creativity, the judicial wisdom, the judicial craftsmanship. They have all widened the scope of the freedom of speech and expression, but subject to all the limitations. And when you refer to that McDonald's case also, kindly see what happened. Ultimately, what happened? Ultimately, the private parties, they stood to lose, right? Because we are living in a democracy. Now, as rightly said by Ramkumar sir, now the press people, they have all the freedom. Now just see, merely because that Indian Express newspaper's case of 85 said that the press plays a very significant role in the democratic machinery, just see how they are running the show. We citizens, we have to be ashamed of ourselves by promoting such cheap medias. Whenever some case props up, immediately the media, they commit the media trial. Is it proper? Answer is an emphatic no. We are having the courts of law. Now the media, they are posing as if they are judges. You can see the 9 o'clock news. They are interviewing everyone. And some of the, some of the newsreaders, they are seen cross-examining as if media trial is being held. Isn't it opposed to the even to the right of life to that particular accused? Can you do like that? So, whatever that be, there should be some control, and especially under the semblance of this freedom of speech and expression, you cannot transgress the boundaries. I am of that specific opinion because we are all bound by the Constitution, which we treat as the most sacred document, which we see in the Sabarimala judgment, as observed by Justice Nariman. Kindly see the judgment. It's a living document. We are bound by the document. Every law that derives, or rather, it derives the strength from Constitution, because it has to pass the muster under Article 13. As well as on the
frame, let us even think international. As long as you are not the victim, I subscribe to Sujitha. When you are the victim, what do you do?
See, that is why.
Let us talk about this salutary, what do you call,
I'm coming to that. I'm coming to that. That is why Section 198 and 199 of the CRPC, it is couched in such a manner that the person defamed has to go to the court of law instead of making it a police case. And kindly see, when Advocate Haridas was saying that 199 of the CRPC, that should be amended. See, 199 of the CRPC, that rather provides, in my humble view, a special procedure regarding initiating a prosecution for the offense of defamation if it is committed against constitutional functionaries and the public servants who are mentioned therein. See, then it is what is initiated is a complaint by the public prosecutor on receipt of the previous sanction of the competent authority in the state or the central government, as the case may be, which we see in the subsection 4 thereof. See, that envisages a departure from the normal rule of initiating a complaint before a magistrate by the affected person alleging the offense of defamation. Why? The rationale for the departure from that normal rule, you can see exactly. It is seen in that PC Joshi versus State of Uttar Pradesh, AER 1961, Supreme Court, page 387. Kindly see the judgment. the core reason which was held that the rationale for the special procedure, which was engrafted under subsection 2 of 199, is that the offence of defamation is committed against the functionaries who are seen mentioned therein, is an offence which is committed against the state, because it relates to the discharge of public functions by such functionaries. So the state would be right in, or rightly it would be interested in pursuing the prosecution, and hence there is a special provision and a special procedure. So PC Joshi's case, that has specifically dealt with this particular, of course, that was one regarding the CRPC of 1898, where we had a pari-materia provision instead of section 199 in the new CRPC. The other was 198B of the CRPC of 1898. Supreme Court has clarified this thing. And see, there is a rationale also behind that.
And some of them may be politicians, but they are people's representatives, elected representatives. They may be politicians.
Representatives, they are politicians. And see, that procedure, if there is no such procedure,
Reasonable classification.
exactly, it's a reasonable classification, and that has passed the muster also. So that particular thing, of course, because as far as the right of a functionary is concerned, I would say that particular offence is post-centric. 198 is person-centric. That makes a difference. One is post-centric, the official post-centric. Other is person-centric. So that makes a difference.
Prem, the host of all these provisions, constitutional mandates. Let us take human rights and human dignity.
Of course, human rights and
you want absolute freedom to say something. Fine, you say. What about when you're on the firing end? Receiving it?
See, even the accused right of presumption of innocence has been elevated to a human right by the Supreme Court. At least there are at least 4 decisions.
Sir, dehost the provisions, dehost the Constitution, dehost the Supreme Court. Are we not human beings? You want complete anonymity. You want to hide behind some sort of clock and make accusations. And you would like to say?
Okay, then let me ask you one thing. If you are saying that the Constitution guarantees you like this, now please see. As far as the right of speech is concerned, you can classify the right of speech like one is freedom of press, which I have already said. Now the second thing, you have the freedom of commercial speech, because through commercial advertisement, which we saw in the Mahanagar Telecom Company Limited's case. Now kindly see, there is a right to broadcast. You can see that Odyssey Communications case, where the Supreme Court said, in with regard to a state channel and Doordarshan, that also is under Article 19(1)(a). And under that right to broadcast, some of the channel, they start broadcasting all sorts of pornographic movies, saying that we are having the right to broadcast. Can it be countenanced in law, saying that it is fundamental right? It goes, see, suppose if it is in some European country, of course, because the society is like that. I'm not blaming the Europeans, kindly don't mislead me. I'm merely saying their society can take that particular thing, but we Indians always treat it as a taboo. So under the right to broadcast, if some of the channel starts broadcasting all these kind of porn movies, can you countenance it saying that I have the right to broadcast under 19(1)(a)?
I'll take a natural corollary also. When somebody says that our environment says something, can it be imported to some other country? It cannot be. It is geographic specific, if I may say so.
So I didn't catch that point. Repeat, Shyam.
It's only geographic specific. When you say that, when we had this 2 and 3 hours of interaction, which I said, when you wanted anonymity, it's wonderful to offer anonymity to those persons who are responsible. I put it in italics. Responsible. But what about it in the hands of irresponsible characters? How do you distinguish? Where is the filter? Where is the culture?
No, before that, just one more thing. Let me just ask you, Sujitha madam. You were referring to that McDonald's case. Ultimately, what happened? First, it was taken back to the High Court, then went to the Court of Appeal. Then I think it was mentioned. You mentioned Article 21, which may be akin to that. Whatever be that, the basic human rights which you have there in UK, and UK doesn't have a written constitution. It is based on what you call the European Code of Human Rights or something like that. Am I right? I'm not that sure, because UK doesn't have a written constitution.
Okay.
Just see ultimately what happened. See, we are even in a state like that, even in a society like that, what was held in the judgment in a democratic society, even small or informal campaign by the groups, they must be able to carry on with their activities, not affecting the others. Right or wrong? Because it is in the general public interest, Article 19, Clause 2 has been so designed. Or else tomorrow, if Article 19, Clause 2 goes off the Constitution, just imagine the plight. So I don't think that it should be restrained. It should be restrained. That's my personal opinion.
Prem, everybody is entitled to their own opinions or views. So we are not here to contradict or anything. And there is no question of
But I would like to answer.
No, it's not a question of answering. Please, ma'am. There is no question of countering or answering, because we are not in a debate, or there is no cup in the end of the session to be handed over.
We are only airing our opinion.
I'm not trying to. No, I don't.
1 second, sir. Ramkumar, sir.
We are only airing our individual opinion. That's
Absolutely, absolutely. And like we say, unless and until the lions have their own historians, it's always the hunters, stories of the hunters, which will be glorified. Today, definitely, Sujitha, you'll be given your time. Just what I'm trying to tell you is that we had an ecosystem which is completely, I don't know, Singapore, or for that UK, and compared to India, and we had difference of opinions. And end of the day, it is not disputing anything or everything. It's only airing our views. But on the academic front, let us hear your views on what has been expressed and not countering that, please.
I mean, why would you think I'm countering it for countering?
Because it's only positive time. I don't have 2 hours time on the phone, please.
Okay. No, I mean, I think, many of the views that have been expressed are, on a similar wavelength. So I guess to a large extent, I will be able to respond to them in a collation. So okay. How is Article 19(1) worded? There's lots of freedoms that are given there, lots of rights that are given under Article 19. If I am correct, I think there is only Article 19(1), which says that it doesn't say you have a right to speech and expression. That's what it says in all the other provisions. It's the only provision which says you have a right to freedom of speech and expression. And yes, I 100% agree that Article 19(2) is necessary in order to bind that freedom. None of the freedoms should be unrestrained. It is clear that there must be some restrictions that are placed. Even in the US, where there is, right to freedom of speech in a very libertarian way, they do have mechanisms to bind it. So I'm not advocating that it should not be bound at all. The question merely is, how do you remedy wherein someone's right to freedom of speech has been affected? There are quite a lot of points that were raised. So I'm going to try and pick one by one just from the notes that I have made, but maybe I will go all over the place. So for instance, what Prem Raj was talking about, the media trial and there must be some control. That's the word.
Please don't answer any of those comments made. Just,
no, I'm not answering them. I'm just trying to.
I'm just requesting you, like, absolute freedom of speech and expression. Justify within 1, 2, 3, 4 points. I don't even say, I'm sorry about the term.
I never advocated absolute freedom of right.
No,
I never said that.
And Prem, probably I think Sujitha is not in favor of removing the restriction provided, but only she wants to say why criminalization is required for this when it can be compensated with money.
Precisely my point. Yes,
let us say that in a 1 or 2 points so that we can say that we'll continue the session tomorrow.
That point we got it. We got that point. We got your point very well.
But if, I mean, you raised a number of points. Is like, for instance,
don't answer the point. Don't answer those points.
No, no. I just want to express why there is it needs to be taken into account within a context. So, for instance, in India at the moment, you do have criminalization of reputation defamation. That being the case, why do you still have the problems that you have all pointed out? Shyam, you pointed there are problems in India.
If law was the remedy, just invoking, or rather, making law was the relief or panacea for everything, then we should have made laws and set it home. It's not that.
Yeah, that's what I'm saying. So criminalization has not necessarily given you what you wanted.
Don't generalize.
One more thing. Sam, before that one.
Don't take Singapore or UK as an example. Whether we have it or not, don't say.
I did not engage in comparative methodology.
Please.
Sam, before that, one more thing. See, even regarding, because Shyam, etc., were saying the right to broadcast has been provided as a right. So under the cover of that right to broadcast, the people are misusing it. There is a view now has come, and I think that is pending before the Supreme Court, as to whether any further restrictions will have to be given on media in doing such things. That is sub judice now. That is sub judice now.
Yeah, I mean, for instance, the question of this right to broadcast, freedom of press, media trial, blah, blah, blah. All of this can potentially be dealt with.
One second. I mean, if you will permit us, we can articulate that. Number one, are you advocating absolute freedom of speech and expression without? One second. Let us confine our scope of discussion to a few things. Are you advocating absolute freedom of expression because of any restraints?
No.
One. Okay. Two. What are the restraints you would advocate?
The only restraint that I am The only restraint that I am discussing right now is in relation to
which you advocate.
That is all the existing.
Let us not confine to what you would feel or something. You want anonymity. You want freedom of speech and expression. Just give me 1-2 examples.
I think there are 2 ways in which I can answer this. One, I might have my personal opinion, blah blah blah. On the other hand, I can say,
let us go by your personal opinion. You are not considering anything else. Go by your personal opinion. Give me.
No. I am only speaking, let us confine ourselves to the issue of only defamation, because when we are talking about seditious libel, we are talking about
you are not representing any institution or establishment. You are not representing any institution or establishment or established thoughts. So please express yourself openly. Just
so if I got her correctly, she wants all the existing restrictions to be in place sans criminal defamation. Right?
My main problem is with criminal defamation. That is what I'm talking about.
Let us get to that. So all the restrictions in place except for criminal defamation.
Yes.
Right?
I think other restrictions has to be read down. Some of them, I don't want to go to the details of it, because then I'll have to look at it and then I have to explain that, and we have not yet finished the issue about defamation, which is what I want to discuss. But in terms of defamation, yes, defamation must remain and will remain, of course. I'm not asking for it to be removed at all. It has to be part of Article 19.2. My only point is that section 499, that is my issue. Section
Criminal
499, criminal defamation.
For the sake of discussion, or to confine our discussion to certain topics, number one, you want restrictions, fine. But you don't want this criminal defamation things to be in place, right?
Defamation should not include criminal defamation.
At least
Yes.
section, can we be in agreement without
Yes.
so many roundabout things?
Sorry, can we be in
Can
agreement
we
with
be
what?
in agreement on one aspect, like criminal defamation cannot be there. At best, you can go about with civil remedies, tortious remedies, and whatever remedies available other than criminal remedies.
Yeah.
Fine.
Yeah.
Now,
Yeah.
no. Let us just get an answer from you straight away. It's not confrontation. It's only what you call discussion. What is so bad about criminal accountability?
Okay, so if you look at what is actually stated in 499,
Forget
we need to protect is reputation.
Sujitha, please forget sections, cross sections, bisections, and intersections. I'm just asking. Just give me why you should not be criminally held. Whatever be the jurisdiction, whether these sections in India or elsewhere in Iceland or New Zealand, I'm not concerned. Why you should not be held criminally liable? Because civil liability at best is compensation. If you are as good as me and I'm not able to pay up, what do I do? But why can't I be held liable for criminal consequences?
See, this is a question about justification for the existence of any specific provision. So, for instance,
Please, let us
look at
Sujitha, let us not go to provisions. Let us not go for what you call sections, cross sections. That's what I said. Forget about all those things.
Yeah, you need to allow me to speak.
No. Just. I mean, if I allow you to speak, speak, there's an issue. I just give you two questions. Then thereafter you can speak. I mean, what is wrong in you being held liable under the criminal jurisprudence of that jurisdiction? I don't care about India or Antarctica for that matter. Why do you want to escape? No. When you say that you should be held liable for civil liabilities, then you say that you're doing a wrong. What about criminal jurisdiction? If you're doing a wrong, why alone civil jurisdiction?
Okay. This is in relation to justification of laws. So, for instance, every single civil provision, you can ask the same question. Why can't you make it a criminal offense? The reason why something is not made a criminal offense is because it becomes arbitrary and excessive, especially when it's in relation to the protection of private interest. So, if you're effectively stating that it's a reputation of a person that is being protected, you need to be clear as to what you mean when you say the reputation has to be protected. What is it that you're protecting, and why is it that you're protecting that? So, in effect, if you're looking at reputation, in three ways you can look at it. Either you look at it as an issue of compensation, or you look at it as an issue of vindication, or you look at it as an issue of rehabilitation. If you're merely saying that my dignity has been affected, so if your dignity has been affected and someone goes to jail, then is your dignity being restored? What is actually happening there? If your dignity has been affected,
civil jurisdiction, where do you get your restoration of your dignity?
Sorry?
Civil jurisdiction, where do you get your restoration of your dignity? You get only compensation or damages. Where is restoration coming in?
The way reputation has been defined is in terms of dignity. That's what I'm saying. Sometimes in terms of dignity, you need to look at the definitions, because that's how you're framing the legislation.
Can you go by the statute? Statute is there in place. You implement the statute.
If the statute doesn't define reputation, that's the problem. If the statute has defined reputation, then we don't have an issue. The problem is the definition for reputation is being given by the Supreme Court. And the Supreme Court has created a multitude of language around the word reputation. This is the problem. So if, for instance, the Supreme Court says it is honor that we are protecting, it is dignity we are protecting, but in another judgment, in the honor killing judgments, oh no, honor is not something to be protected. Reputation of a woman, things are not something that needs to be that needs to be taken into account in relation to honor killing, and therefore we need to lay guidelines. So in one hand, you're saying honor needs to be protected. Another hand, you're saying honor need not be protected. So the question is, what is honor that you're talking about? So that's the precise issue. You have to make a clear-cut idea as to what is meant by reputation. Is it honor? Is it dignity? Is it property? What is it that you're protecting? The way it is defined in the legislation, it looks like it is property, because it says, oh, how is your estimation in relation to third person affected? When you're talking about dignity, dignity has got nothing to do with, when you're talking about personal dignity, my personal integrity, me as a person, an integral person as such, that is not in relation to your, how you're being estimated by a third person. When you're talking about estimated by a third person, then you're effectively saying that something has been lost in terms of something which I have contributed to gaining. Dignity is something you're born with, while reputation in terms of property is not something that you're born with. You gain your reputation. You more or less, you work towards reputation. You live a good life, and then you have reputation. You do good acts, you do good behavior, and then you have a reputation. That is treating reputation as property. You need to be clear as to what is it that you're protecting. Are you treating reputation as a property that you have gained, that someone's person X reputation is greater, mightier, bigger than person Y's reputation because he is, I don't know, a thief, a robber, or someone who is a man of ill will. So if you're talking about, if you're trying to distinguish people's reputation, one person has more reputation, other person has a different reputation, then effectively you're treating reputation as a property. But if you're treating reputation as a dignity, that's a different thing altogether. Everybody has dignity the minute they're born. They're not working towards dignity. They're born with dignity. If you're treating it in that way, the protections that have to be given to reputation is completely different. And if you're treating reputation as an honor, it's a completely different issue. Because if you're talking about honor, you're stratifying society. You're effectively stating that, yes, it's very good that we have a caste system. It's very good that we say, for instance, to call a white man a Negro used to be an offense until 1958 in the US. But to call a black man, if you call him white, he does not have any remedy. Why? Because of the stratification in society wherein you're treating effectively the white person to be more important than the black person in society. That needs to change because you're talking in reference to honor, and the person, the white person, treats that he has a set of honor which has been granted to him within the societal stratification that exists. So my point is, you have to be clear. What is it that you protect? Is it honor? Because if it is honor, then we are effectively saying that, yes, it's good that we have a discriminatory society, and that cannot be right. Because in the Constitution, the Constitution provision actually states that we should not have honorific titles. We get rid of honorific titles. No person is more mightier than the other. In fact, the president and all these public authorities are not our monarchs. They're not someone who rule over us. They're not a ruler. They are defined as public servants. They're meant to be serving somebody. This stratification is not something that is accepted under law. Of course, it happens in society. In society, people do look at upper caste, lower caste, wealthier person, non-wealthy person, and so on and so forth. But that is not something that exists in relation to the legislation. The legislation treats everybody equally. If the legislation treats everybody equally, then it's not possible to treat your reputation as an issue of honor. The only other way to look at it is to say whether it's a property or whether it's a dignity. And if it is property, then of course you need to compensate for loss of property. It happens also in intellectual property law. That's also intangible law. When you're talking about passing off or any such stuff, you're saying, okay, my intangible right has been taken away. So how do you compensate for that intangible right being taken away? But if you're treating reputation as dignity, as a matter of dignity, the concept of gaining back the dignity is something about rehabilitating your dignity. Someone called me a thief. Someone called me a robber. Now, how do my reputation come back to me if you're treating it as a dignity? does it come back to me because someone has been jailed? That is, his personal liberty, Article 21, is affected because he's been thrown into jail. But does that make me not to be treated as a robber?
Sujitha, isn't it like the argument that somebody has been killed? You give the convict or so the accused, capital punishment. Does that bring back the other person to life? If it doesn't, how do you give capital punishment? So you are an advocate against capital punishment? I don't know.
Well, I mean, personally speaking, but legally speaking, as a legal researcher, I am against capital punishment.
Wonderful. That reflects in your presentation also. Okay.
But personal, no.
No, unless and until you are murdered, it's okay. So what I'm trying to tell you is that unless and until you are the victim, unless until you are exposed to these sort of
mental torture.
Absolutely. So it's very easy to justify things. It's very easy to say that you have.
Okay. Let me give you a case. There is a case, I forget the name of the case, Lily versus Newcastle Council. I'm giving a UK case.
No, Sujitha, I was just asking you something like that. Putting somebody in prison won't bring back your reputation. Fine. Getting compensation, will it? Then get away with that also. So you go for absolute freedom. Whatever you want to say about other person, you say. So civil or criminal prosecution should not follow.
No, even in the case of civil liability also, Sujitha, if I think there are two types of compensation. One is nominal compensation and one is for special damages. Yeah. See, nominal only say because your reputation has been harmed, but you didn't sustain any loss. Loss in the sense financial loss is not there for you. So that can be compensated by providing nominal damages. Thereby, in a way, you are restoring that what is done by him is wrong. That is being restored, saying that he is one. So it is not the question of payment of compensation alone, that is not going to restore your reputation. But ultimately, how it affects the society, if it is still likely allowed to continue, is the question. All criminal offences, hear me listen. All criminal offences, if you take, there is a civil element. For example, cheating. Purely it is a civil, because some loss has been caused on account of this act. You can compensate it. Why should it may be criminalized? If you take in that way, every criminal offense can be characterized as civil liability, can compensate that. There is no necessity for criminalization at all. So that will go to anarchy sometimes.
Sir, if you go to Middle East, there is blood money concept. You can commit murder, you need only pay money. So let us not generalize things or take minuscule countries or places like Singapore or UK to justify things. Maybe they did rule the world earlier on, but not on philosophy or.
No, I also, excuse me, I took the example of Zimbabwe. They didn't rule India. In fact, they suffered.
Zimbabwe is what compared to India? Maybe, I don't know, half of my acre of property, nothing else.
Well, I told right in the beginning that I'm not engaging in comparative methodology.
Sujitha, we are not disputing anything. We are only debating. When we debate, heated debate has to follow. And don't take it so personally. Even I am not.
Every Indian Supreme Court ruling that I read, it starts and talks about so many different countries.
You got a difference of opinion with Supreme Court of India. You have it, not with us.
Issues which are totally irrelevant, and it still uses it.
Absolutely. I mean, who said that this platform subscribed to Supreme Court of India? This is not run by Supreme Court of India.
Yeah.
So, this is run by certain characters who has got the the courage to think openly and deliberate things. So please don't subscribe or view us in the concept of Supreme Court of any country for that matter, let alone India. Ramkumar sir.
No, we have already made
not on that. Somewhere we have to come to a conclusion.
Yes.
Sujitha has made a very strong point. It's wonderful. She has made it very strongly so eloquently that I like to disagree.
She also wants reasonable restrictions in Article 19.2. So,
no, she wants reasonable
even
restrictions in this platform against her views.
No, even defamation she wants. Sans criminal defamation. Defamation sans criminal defamation. That's all.
That's correct.
We got her point.
Let us deliberate on that, because that, of course, I mean, even for a second, in spite of all the strong opinions expressed, maybe defamation or freedom of speech and expression should not be curtailed by criminal prosecutions. Might be a view available in those countries wherein civil consequences are sufficient. But I'm not very sure about India.
But the right to free speech should not be exercised in such a way as even to commit criminal defamation.
That's what I mean, sir. There again, the distinction which Sujitha would like to draw is, I mean, with due respect, is that you are not supposed to make any, I mean, indecent or other, I mean, unacceptable statements, but it should be visited only with civil consequences, not
even then. Even then, there is no reparation. Even then, parties are not brought back.
I mean, it's just like an economic theory. Everything else remaining constant. It starts with that. Here, everything else does not remain constant.
Even there, parties are not brought back to the original condition.
I mean, a small country like UK or Singapore or some other place can have these sort of things. But
the civil defamation has been committed.
You can just disappear from the entire scene. What do?
The speech, the civil defamation has been committed.
Correct.
Whatever be the compensation awarded by court, that will not restore.
We understand the theory, whatever has been advanced by Sujitha ma'am, but the issue is that whether we can subscribe to it or not is of no consequence, because it's only exchange of ideas. It is only
Listen, Shyam, first of all, you are misrepresenting when you're saying that we cannot be like Singapore. In fact, I'm actually saying the opposite. I'm saying Singapore should be like India, because Singapore does not even have reasonabness as part
Calicut
of
city can be like Singapore, but Singapore cannot be like India. Let us be, I mean, let us not dispute on a small country.
I think that this is a personal issue that you might have in relation to other countries. I mean, let's talk about legal issues. If the question is merely whether compensation or damages can do the reparation. Like, for instance, it was already mentioned, sometimes nominal damages can be given. The nominal damages is seen as sufficient to restore the person, which is why the nominal damages is being given.
By whom?
Unless, of course, there has been a financial...
By whom? Given by whom?
The court.
By the court. Fine.
Yes, by the court.
End of the day, are you satisfied with that?
See, it is not a question of, it's not a question of your personal feelings. It's a question about law.
Wonderful.
What does the law provide? I mean, you might want to put everybody in jail, but that cannot be made a law, you know. I mean, we have to go by what the law states. And I'm looking at what the law states rather than what, you know, my personal feelings may be.
What states?
What the law states.
Law states. Law of the country states that you have got criminal consequences. You respect that. Finished.
Yes. So I am effectively stating that the constitutionality of that provision must be examined by the Supreme Court, which is also provided by the law. To ask for judicial scrutiny of a particular legislation is allowed. You know, it's not something which is, I'm not asking for a dictator to come and scrap out the laws. I'm asking for something which is a part of the legislative provisions.
We fully understand and appreciate that. It's a wonderful presentation. And
we will expect Sujitha to move the Supreme Court one day.
With this not just one day, tomorrow itself.
No, probably when Puttaswamy's case was reviewed, because some review petition is pending before the Supreme Court as to whether
the thoughts and the whatever she has said is wonderful. It has to be across. Whether we agree or disagree is something entirely different. But she has approached the issue is wonderful. That has to be appreciated and has to be placed before the concerned authorities. according to me, to be repelled for them to be accepted.
Not that. No, she is subscribing to the views taken by Dr. Subramanian Swamy when he filed the petition before the Supreme Court to decriminalize. That's all.
Correct. That's correct. No, if 138 and what you call bounds of check can be decriminalized, why not this? Would be a question.
Sujitha can be at least an intervener.
She can. She is wonderful. She is very tenacious also.
Yes.
So just see one thing: the constitutional validity of 499 and 500 that has been already settled by the Supreme Court. Again, you are saying that again it has to be resettled.
It has to be settled by a constitutional bench, is what I'm asking.
See, why need a
bench?
Let me tell you.
Ask for anything.
No.
Let's take the lead. Let her take the lead.
No, instead of Subramanian Swamy, you just refer to DC Saxena's case, 1996 5 SCC 216. Just see what exactly was dealt with. Why do you need again to conduct a post-mortem of Subramanian Swamy? And when you yourself are on Asi, I'm not against your view, I may not be against your view, but as far as Indian law is concerned, when we have this in our statute book, we are all bound by the statute book and the constitution. And of course, maybe in UK, you have a different set of law as you would preach. But let me ask you a simple question. Just see what is the law in UK. One of the leading cases which was referred to in Subramanian Swamy was the Bonnard versus Perryman. It's an 1891 Chancery Division Court decision. I don't remember the citation. Something, I think it was Lord Coleridge. His words were expounded. His words were, the Supreme Court, they have made use of the words which were used in that judgment. And then there was Fraser versus...
But do you know, all the judgments that were referred, the UK judgments, the US judgments that were referred by the Supreme Court in India in order to define reputation and to say, it's the honor, it's the dignity, blah, blah, blah. All of them happen to have civil remedies.
Then again, we are falling in the groove wherein you want whatever referred to by the Supreme Court. Maybe by the Supreme Court.
I only said it because Premraj said it.
No, Premraj did not say whatever referred to by Supreme Court. He was even going
he mentioned the case referred in the Indian.
Correct. He was referring to a Chancery Division case referred to in that. Let us go to the Chancery Division case. What is it?
Yeah, but that one has civil remedy, not criminal remedy.
Let me put it this way. The constitutional guarantee of freedom of speech, does that confer? Take it this way. It says freedom of speech and expression. Now, whether that freedom of speech and expression, whether I would be right to say that it confers a right to defame a person or to harm somebody else's reputation by false and baseless allegation and by inventors or insinuations, can you do like that under the semblance of article?
But I never argued that. I said it must be restricted. I said that defamation must be something that ought to be, a person must be protected from being defamed. I said all of that. My only query is, when you're saying, legally, not personally, legally, when you're saying that a person's reputation has to be protected. So look at, I'll give you an example. It's a very, very, serious example of exactly what all of the examples that have been referred to so far by the various speakers. In this particular case, Lily, two primary school teachers, nursery teachers in Newcastle, they were accused by the council and the committee that was appointed by the council of sexually abusing a lot of primary school children. And the report was given to the press. The report was published without asking them or letting them know or telling them what is actually being said in it. Literally, they were being accused of being pedophiles, of having sexually abused children in their nursery, dozens of children in their nursery. all of it turned out to be false. This was actually done by the council. It was actually done by specific individuals, which were put in a specific committee appointed by the council. And it was published completely across UK. It turned out they had to move home because of all sorts of attacks in their homes. They had to, you know, for 9 years, they fought the case. At the end, they were, it was considered, yes, of course, it was found, all of the allegations was found to be false. And the court awarded £200,000 each, which is not, you know, in terms of, you know, money. It doesn't adequately compensate, I would say, for the effort, the problem that they went through.
Had it been the other way around?
Exemplary damage.
Correct. Had it been the other way around, like, I mean, had it been true and that person had not spoken? Both you are saying that there should be freedom of speech and expression, and it should not be.
Sorry, repeat your question.
Where do we stand with that example?
What I'm trying to say is, here what was being restored for the person, you know, I mean, when eventually they were found to be not guilty, and the information, you know, came out. Of course, it was published as news.
So you say that I mean, whatever little compensation was not adequate enough.
In terms of protecting the dignity of, protecting the dignity of a person, the person's dignity is rehabilitated. I'm using that word as opposed to vindicated, where you're telling, you know, throw him in jail, kill him. Have
you had any occasion of persons who being unnecessarily accused committing suicide? How do you rehabilitate a dead person?
You can't rehabilitate a dead person.
Then
but the
where
question,
do you go?
Yes, so then you're not treating, literally, you're not treating, you have to define what is it that
your freedom has to stop where other person's freedom has to start, right?
Yes.
I am not advocating. Just give me 1 second. If you make accusations on somebody which that person is maybe sensitive, super sensitive, whatever it is, he is no more. Whatever things you do, can you bring him back? Is it not saying that criminal offenses, everything? If that person who's made that comment has to be made liable and responsible. Right.
So you put someone in jail for 2 years. Will he come back?
No, he won't come back. But you are being punished. One second. You are not being punished for stealing a horse. You are being punished that horses shall not be stolen in future.
Yes, but that hasn't stopped people from defaming, has it?
See, what about compensation? Does it wipe out the stigma?
Correct.
Does it wipe out the stigma?
No, the stigma, I mean, for instance, in this particular case, the stigma is wiped out, wherein they come again, they are published in the newspaper stating that, oh, these people have suffered from the council treating them as pedophiles.
Why not both? Why not both?
Their reputation is rehabilitated when the truth has actually been published.
Sujitha, why not both? See,
not fully.
You cannot recompensate. You cannot do anything. That person is no more. Why not punish this person as well as give recompense or compensation? What prevents you from? Why do you want to perpetrate injustice or this sort of mischief? Why do you justify that?
Let me answer that in 2 ways. Let me answer that in 2 ways. In every example that you have in mind, when you're saying that a person has to be,
because the law of the land gives you reasonable defenses, saying the truth, etc. You say you are a whistleblower. Fine, good. But when you do a mischief, why do you want the criminal prosecution completely excluded?
What you're necessarily seeing is that whistleblowers or potential whistleblowers are the ones whose information is being lost to the public. The opportunity cost of all these people going to courts instead of actually writing the truth. They may well be writing the truth. The question is, the truth itself is not a defense. That's the problem. If truth has to be for public good. Why? If the person is saying the truth about somebody, why is that not necessarily treated as an adequate defense?
If you don't take it in offense, you should be living in war.
If it is a case of whistleblowing, you're literally losing information, literally losing all the potential public, the public has a right to know what's actually happening behind
we have somebody like you in India. It's not as Arnab Goswami or I don't know, something like that. But to be frank with you, it was a wonderful presentation of your point of what do you call
decriminalization
perception about the freedom of speech and expression, which maybe many of us would have subscribed, but I have reservations and others would have reservations. But reservation is nothing. But this is a platform wherein we encourage free debate and free thoughts. So before we wind up, Prem?
Yeah, I would just say, even though I had said maybe contra to what Sujitha was preaching or rather propounding, I would also tell that these are not far, because I think, madam, you have not referred to a judgment of Kaushal Kishore versus State of Uttar Pradesh. Kindly take note of that. 2018, 11 SCC, page 561. Kindly take note of the judgment. That judgment, that was an interim judgment which was reported in the SCC. In that judgment, Mr. Pali Nariman, who has been appointed as the amicus curiae, and that exactly a case which you propound, that there cannot be a criminal prosecution on the ground of decency or morality, that is under challenge, and the Supreme Court is yet to pronounce a judgment there. So you have a fair chance, maybe. Even though I have talked against you. True, at certain times maybe, but unfortunately we have a law. You have one judgment in your favor of the Supreme Court, and that matter is still pending. Mr. Senior Advocate F.S. Nariman has been appointed as amicus curiae in that case. It was a wonderful talk, madam. It was a very wonderful talk. Whatever, because I would always stand by you, because I am also a person who just moves against the current. It's a wonderful thing which you have done. I really appreciate you for your boldness. And you really are a firebrand.
Prem doesn't want to be convicted. So he would like to be a law propounded by you.
Somebody has to come and propound the views. Because
absolutely.
You cannot say because her dissent, her lone voice, that can become the voice of tomorrow.
Absolutely.
I won't simply brush aside whatever she said is against law.
Absolutely.
In fact, all
you have boldly submitted, and I would say you were bold enough to get hold of your own views and to stand by your own views, despite all of us coming against you. It is wonderful, and stand by your own view, and I wish you, let your view be later declared as law. Unfortunately, we have this, or else rightly, I would have gone with you. Thank you so much.
Sir, some of the dissenting judgments later on became the law.
Absolutely, sir.
No, even the adultery and 477 subsequently held to be not criminal offences. So, possibly
you have a wonderful platform wherein whatever you have been said, whatever you have said has been vindicated in the sense like maybe it's not palatable for the time being. Maybe tomorrow.
So it is not palatable only for the reason that we already have a law and we are bound by the Constitution. But to be very, very frank, what you have propounded is an absolutely acceptable view. I cannot say it merely confines to academics and all. I won't say like that. Your view is perfect. This particular thing has not been considered in the greatest detail by the Supreme Court. Even in the Subramanian Swami judgment, what you have said is absolutely right. They caught hold of some Mahabharata scriptures, something from the Shakespearean poems, and they then went on to say that this is dignity. See, just see, modesty of a woman, is it defined? We unfortunately have section 354, which still all the judges are also blind. What is modesty of a woman? It can depend, it can vary from person to person. It can vary. See, just see, it
is there from the birth.
Minister Arun Jaitley. Arun Jaitley sued Arvind Kejriwal seeking for 100 crores. And the question which was put to him by the great Ram Jethmalani during his cross examination was, now how do you compute this 100 crores as the damage for your I mean, the damages for your reputation. And Jet Li could not even answer. You cannot answer that directly. How do you compute? How do you calculate? You have to modestly estimate, right? Now, how you are going to calculate? Is it based on your income tax statement? Somebody's estimation, can that be calculated in terms of money? Answer also is an emphatic no.
Correct.
Even in
It's also here also it will be like here also it will be like
your view ultimately come up, because we are all waiting for this causal judgment to come. Let the judgment come, and I strongly feel that maybe one day or other your view would be upheld. Even though I went against your view, I did not make mention of this judgment at that point of time, merely because you were fighting on, and this mode of fighting as a lone voice, that is the best thing which you can do. And you are brave enough. I would say you are a firebrand. Excellent.
No doubt, no doubt.
lone crusader, a lone crusader, but we will have the same fate as Lady Chatterley's lover.
Sujitha, today, in fact, it was not just wonderful, though you faced a firing squad, you fared well. Not because of the firing squad was bad enough or your presentation was good enough, but exchange of ideas. The way we were able to assimilate things, simply awesome. Thank you for introducing the subject. Thank you for going ahead with your pattern of thought, which, like Prem said, may be accepted or may not be accepted. I'm not concerned with that. But
Offbeat.
Wonderful, and
Excellent.
Sujitha, keep it up.
Thank you ever so
And
much. I mean, this is
you got an
really,
entire
really
team behind you.
Excellent. Now, who is the
Actually,
who is the speaker tomorrow?
Sir, tomorrow 3:30, no? Just
Tomorrow 3:30.
So I just let you know.
Okay.
So Sujitha, thank you. And
She has
thank you all.
already gone.
Till we meet 3:30 tomorrow.